Mr. Chief Justice, and may it please the court, my name is Jomar Marquez, and along with me is my co-counsel, Iris Alvarado. Today we'll be representing the petitioner Roper. We asked to seek to protect the state's rights in serious crimes, including the ability to hold 17-year-olds accountable for when they act with intent and violence.
The essential question today in front of the court is whether executing a 17-year-old is cruel and unusual. The Eighth Amendment bans excessive punishment, but doesn't punish for offenders who understand what they did and who were 17 at the time.
Our interpretation of the Eighth Amendment is that the death penalty for minors is constitutional under the law. Even under the age of 18, minors know what's right from wrong, and when they commit deliberate violent crimes, they should face the same consequences as adults under the Eighth Amendment.
Christopher Simmons was 17 when he planned and committed this brutal murder. He told a friend beforehand, Benjamin, that he wanted to kill someone and believed he could get away with it because he was a minor. They broke into the home of Shirley Cooks, where they tied her up and threw her off a bridge, where she later drowned. After receiving a tip, the police arrested Simmons, where he later confessed and even reenacted the crime in front of the investigators. The jury convicted him of first-degree murder and sentenced him to death. But the Missouri Supreme Court later overturned that ruling individuals under 18 cannot be sentenced.
We do not contend the Eighth Amendment rule against excessive punishment. However, that protection does not execute premeditated violent offenders who fully understood their actions. The precedent set in Stanford v. Kentucky shows that 16 and 17-year-old minors know what's right from wrong and can be held fully accountable under the law. The court found no national consensus against executing older teens and affirmed that Simmons may decide whether the death penalty applies to juveniles of that age. This directly supports our legal position that Christopher Simmons planned and carried out a murder with full awareness. If the death penalty was constitutional for 17-year-olds in Stanford, the same reasoning and precedent should apply here.
After we establish that 17-year-olds can understand what they did, let's talk about brain science. In Eddings, age can be considered, but that doesn't erase responsibility. Teen brains may be developing, but they still know right from wrong. Simmons showed planning, intent awareness, not impulsivity. Brain science cannot excuse deliberate violence.
Showing that brain science can't merge deliberate crime in Wilkins versus Missouri, the court upheld the death penalty for a 16-year-old, finding that age alone doesn't it's constitutional, and older teens understand consequences to their actions. Christopher Simmons bragged about it that he could get away with it because of his age. His attempt to exploit age-based protection shows understanding, not immaturity. Under the reasoning in Wilkins, a teenager remains fully accountable, and the state has a constitutional authority to impress the full legal penalty.
Your Honor, executing 17-year-olds is constitutional because in Stanford v. Wilkins, older teens understand consequences, and in Eddings, states may impose full punishment. Simmons planned this murder, carried out, and even bragged about it. We ask the court to find in favor of Roper. Thank you.
Thank you, petitioners. Questions from the court? So if executing a 17-year-old is constitutional, where should this court draw the line? Is it constitutional to execute a 14-year-old? How do we determine what age is appropriate?
Could you rephrase the question?
So in your facts, the perpetrator was 17. But if the court's going to make a decision that's useful in future cases, should we draw the line at 17 or 16 or 15 or 14? What age is too young?
So currently it's only 16 and 17, but it could be like lower than that but it's all up to the court and the crime.
Other questions? Thank you, petitioners, respondents.
May it please the court. I'm Jada Geese, and I'm here today with my co-counsel Ariel Stoliker, Melanie Hernandez, and Ashlyn Russ. We are here today to represent the respondent, Christopher Simmons, in the case of Roper versus Simmons. The question of this case is, does the execution of minors violate the prohibition of cruel and unusual punishment found in the 8th Amendment and applied to the states through the incorporation doctrine of the 14th Amendment? We, as the respondent, say yes. This does violate the cruel and unusual punishment clause of the 8th Amendment. Now, to outline the circumstances from which the question of the case emerged. Christopher Simmons was a 17-year-old young man from Jefferson County, Missouri. On September 9, 1993, with the help of 15-year-old Charles Benjamin, Christopher Simmons carried out the kidnapping and murder of Shirley Crook. The next day, police brought Christopher Simmons in, where he confessed to the murder. The clinical psychologist who examined Simmons determined that he had a mental disorder, contributing to the fragility of his adolescent mind. Christopher Simmons was tried and convicted of kidnapping, murder, burglary, and stealing. At the age of 17, he was sentenced to death. After multiple appeals, the Missouri Supreme Court vacated his sentence, using the reasoning of Atkins v. Virginia, which dealt with the execution of the mentally disabled.
Atkins v. Virginia provides a strong justification for Simmons' position as the constitutionally correct one. In Atkins v. Virginia, the court concluded that executing people with disabilities was unconstitutional because of their reduced culpability. This made the death penalty an excessive punishment, and this reasoning also directly supports Simmons. Juveniles, like people with intellectual disabilities, have low impulse control, low moral responsibility, and lack judgment. Consequently, Roper v. Simmons appropriately extends the logic of Atkins, demonstrating that executing minors fails to serve the goals of retribution or deterrence and violates the evolving standards of decency in a civilized society. Overall, the reasoning in Atkins v. Virginia reinforces the moral and constitutional foundation of Roper v. Simmons. This proves that society has evolving standards of decency, and we demand greater protection for those with diminished culpability.
We now turn to Thompson v. Oklahoma and Roper v. Simmons. Thompson v. Oklahoma together established and finalized the protection of juveniles from the death penalty. Thompson v. Oklahoma set the crucial standard precedent by ruling the 8th Amendment of Prohibition must be judged by the evolving standards of decency. This was about a 15-year-old who was sentenced to death, which the Supreme Court overturned because it was cruel and unusual punishment, and making the execution of those under the age of 16 unconstitutional. This requires the courts to consider the age and developmental maturity. Roper v. Simmons then directly built on this precedent, and based on this precedent set, Thompson provided the foundational principles for protecting juveniles, and we implore the court to follow suit and rule in favor of the respondent Simmons to complete the protection of minors.
In addition to the initial cases presented, I want to bring forth the case of Trout versus Dawes, which advocates for the evolution of the Eighth Amendment. In this case, Albert Traub was a man who escaped from a military stockade in Casablanca, Morocco in 1944. 3 days after he escaped, he surrendered and was brought back by the warden and was sentenced to 3 years of hard labor, and he lost his citizenship. He didn't know this until he tried to apply for a passport. He then argued in front of the Supreme Court, which he won in his favor, and the Supreme Court ruled that citizenship is not a license that expires upon misbehavior. The main point I want to bring forth is that the Eighth Amendment has to be subject to change. As our as our standards of decency change and evolve with the time, so should our rendition of what cruel and unusual punishment stands for. In summary, the case of Trout versus Dawes is substantial evidence of why we need to be able to modify and change what the Eighth Amendment stands for the good of the American people.
As the respondents, we implore the court to uphold the principles of justice and fairness and review the constitutional issues that surround this case. The Eighth Amendment is in great violation because at the time young Simmons decided to commit his crime, his mind was not fully developed to review the consequences. Based on the reasoning used in Atkins v. Virginia, minds that are not fully developed are not culpable for the death penalty. Furthermore, in the case of Trott v. Dawes, the Eighth Amendment is subject to the ever-changing ideals of decency. So, as society's ideals of decency evolve, so should the regulations of this law. Thank you, Your Honors, for your attention and consideration.
Thank you, respondents. Questions?
Yes, one of your slides said that young people don't have moral responsibility. What do you mean by that?
They lack the understanding to know the full ability of what they're doing. So when they do something, they don't understand your brain isn't developed until you're older, so they don't understand the full capability of what they're doing or the consequences of what they're doing.
Brains don't fully develop even at 18, so would you recommend not giving the death penalty after 25 or 27?
We would advise to, if the rest of our regulations in the country remain at 18, such as being able to vote, pay taxes, and make adult decisions, that things such as the death penalty should remain in alignment with that. Not because their brains develop at 18, but because if the rest of our laws give you adult responsibility, then our justice system should align with that.
You feel at your age that you know the difference between right and wrong, and if you intentionally harm somebody, that you would know the difference?
I personally feel that I know the difference between right and wrong as someone who has grown up in a stable family and has had a normal upbringing. But for someone like Christopher Simmons, he had a sadistic stepfather who brutalized him, and he turned to drugs and alcohol. So at a young age, this type of addiction is already an overwhelming amount of change for the amount of ongoing changes in your brain. So for someone like that, I don't think he would know the difference between right and wrong necessarily. But for me personally, yes, I would say I do.
So therefore, should it be case by case instead of flat by age?
I think it could be case by case because someone who grows up in normal circumstances and in a normal environment, and they have proved before that they know right and wrong. If the court evaluates them and proves them to be culpable, then yes, we believe it could go case by case.
If there are other questions, we'll hear a rebuttal by the petitioner.
I'm sorry, I don't think we've researched this, but where did you find that he had a disability?
The clinical psychologist who examined him after police questioned him determined he had a mental disorder, so not a disability, but a disorder that was clearly developed after the ongoing circumstances of his life, and this was found in the Chicago Sun-Times report of the crime.
So he was diagnosed with one, is what you're saying?
The clinical psychologist who examined him determined he had a mental disorder. They didn't specify any specifics on the diagnosis, but
Further questions from the court? Rebuttal by the respondents.
in the petitioner's case, they have stated that minors understand what they did, know right from wrong, multiple examples such as that, but research has proven otherwise. According to the National Health Institute, in Germany, 62% of teens die from risk-taking behavior, and this is because of the distinguished difference between how teens and adults make decisions. Teens lack the ability to fully process risk, which leads to higher risk-taking behavior in young adult to late adolescent age period. So these adolescents cannot evaluate risk the way that adults can, which leads to them often taking higher risk behavior, which is why in Germany we see these high rates of death for risk-taking behavior, because these teens cannot evaluate these consequences fully, and they choose to do these things because it gives them a higher emotional release, which is what teens are searching for with their underdeveloped brains.
Questions from the panel?
Any information on that same category for U.S. teens?
We haven't found any information on the deaths, but it's still proven in the U.S., especially with drug use, vaping addictions, social media with the dopamine release. Teens are always searching for a higher emotional release, which leads to risk-taking behavior and increasing over time.
Thank you, counsel. The matter of Roper versus Simmons is submitted. The court is prepared to hear arguments in the matter of Carpenter versus U.S. Petitioners, you may proceed when you're ready.
Mr. Chief Justice, and may it please the court. My name is Braden Rosebohm, and alongside me are my co-counsel, Corey Camise and Aiden Kramer. We are representing Carpenter. In this case, the United States government took it too far when it came to accessing Carpenter's cell phone records without a warrant. Those records showed everywhere he went for months, which is very private information. The Fourth Amendment is supposed to protect us from unreasonable searches, and getting that data without a warrant breaks that law. So we ask the court to reverse the ruling in the lower courts and protect our privacy.
The question before this court is, does the government's collection of an individual's cell phone location data from their wireless carrier without a warrant violate the Fourth Amendment? The Fourth Amendment states, protects citizens from unreasonable searches and seizures. Traditionally, these protections are of physical spaces for like a home or a car, but today, much of our private lives exist digitally. This case asks if privacy is the same for our digital lives. In 2011, police arrested 4 men suspected for a series of robberies. One man confessed and gave the FBI Timothy Carpenter's cell phone number. The FBI then obtained Carpenter's cell phone location data from his wireless carrier without a warrant, using a law that allowed access to business records. These records show Carpenter's phone location over a span of 127 days, placing him near the scenes of the robberies. Carpenter argued that this was unconstitutional because the government got detailed information about his movements, which is far more personal than basic phone company data. The government said they did not need a warrant because the data belonged to the phone company, not Carpenter himself. This case asks the court to determine if the government's collection of an individual's cell phone location data from their wireless carrier without a warrant violates the Fourth Amendment. We argue that it does.
The government violated Timothy Carpenter's Fourth Amendment right by obtaining his cell phone location data without a warrant. This results in an unreasonable search and invading privacy. This is true because digital data reveals extensive personal information. People have reasonable expectations of privacy on their cell phone records, and modern technology requires updated protections under the Constitution.
Technological data deserves the same constitutional protection as personal searches. Digital data reveals deep personal data about a person, as seen in Riley v. California. Police arrested David Riley and then searched his cell phone without a warrant. While searching his cell phone, they found text messages and pictures linking him to a gang shooting. Riley argued that this was unconstitutional because it violated his Fourth Amendment rights. The Supreme Court agreed with him. They said that police must get a warrant to search a person's cell phone because modern cell phones hold more personal information than a physical search ever could. We think that the same should happen with Carpenter's cell phone, as tracking his location data would have the same personal information.
Just as in Riley, where digital privacy outweighed police convenience, another case, U.S. v. Jones, shows the location tracking without a warrant also violates reasonable expectations of privacy. Location tracking invades privacy as seen in U.S. v. Jones 2012. In U.S. v. Jones, police put a GPS tracker on a suspect's car and followed him for only 28 days. The Supreme Court said this broke the Fourth Amendment because it counted as an unreasonable search and invaded privacy. This can show where the suspect lives, works, goes to church, and who they spend their time with. Similarly, the government tracked Carpenter's location for over 100 days, which showed his daily routines and personal data without him even knowing. This digital monitoring is just as invasive as a GPS tracker in Jones, if not worse, because Carpenter's phone automatically recorded his location every few seconds when he wasn't even aware of it.
It is essential for the court to consider how the Fourth Amendment has changed because of new technology. It protects people, not just places. In Katz v. United States, the government wiretapped a public phone booth to record a suspect's conversation. The Supreme Court then ruled that it violated the Fourth Amendment, establishing the principle that the amendment protects people's reasonable expectations of privacy. The same reasoning applies in Carpenter's case. Even though his data was stored by a third-party phone company, it still reflects his private life and movements. Just as the defendant in Katz expected privacy in his cell phone conversation, Carpenter expects privacy in his cell phone location data. The government should not be allowed to bypass these expectations without judicial oversight.
Your Honors, this case isn't just about one man's cell phone records. It's about everyone's right to privacy in today's world. If the government can access somebody's location data without a warrant, then none of us truly have the right to privacy anymore. We bring our phones everywhere we go. They hold our routines, relationships, and personal lives. That's not something the police should be able to take without a judge's approval. The Fourth Amendment is supposed to protect us from this exact kind of government breach of privacy. So for that reason, we ask the court to reverse the ruling in the lower courts and rule in favor of Timothy Carpenter and show America that digital privacy still matters. Thank you.
Thank you, counsel. Questions from the bench?
If the police were trying to stop a crime that was an imminent danger to someone, so somebody was kidnapped and they're trying to find the victim, and they feel that time is of the essence, could they break into someone's cell phone then to try to save a life without a warrant because they don't have time to get a warrant?
No, because then it would fall more under probable cause.
Also, street cameras. Lots of cities use street cameras, which also track people's movement. Do people have a right of privacy there as well?
A street camera isn't tracking your exact movements everywhere. Like you have your phone on you all the time, and your phone is showing where your house is, stuff like that. And I don't think a street camera will show his exact stuff.
Does it matter whether the cell phone was automatically broadcasting the data or whether the police got the data from the cell phone?
The phone was broadcasting the data to the cell phone company, and then the cell phone company, the police went through the cell phone company to get the data.
So does that matter though? Because then, does he have a reasonable expectation of privacy if he's providing the location data willingly or unwillingly to the cell phone company that's not a government actor?
I think either way, he should have a right to privacy because we bring our phones everywhere. It's become almost a necessity more than a want. So I think we should have the right to privacy no matter what.
But did you voluntarily give up that right to privacy when you signed whatever phone contract you made with your provider?
All modern cell phones kind of use your location nowadays, and I think you need a phone almost nowadays. So I think it shouldn't be something that you give up because you get a phone.
In almost every modern social media platform, so Facebook or whoever, you give up all of your rights to privacy as soon as you sign up for their clause. Could the police then hack into you or ask Facebook for all of your data for the same purposes?
Not without a warrant. I don't think they should be able to do that.
Even though you did sign a thing or click a thing saying that you give up your right to privacy?
Yeah, you would still need a warrant as it's.
Thank you, petitioners. Arguments from the respondents?
May it please the court. My name is Ryan Hildebrandt, and my co-counsel here today is Lucretia Pablo and Tyson Beek. We are here to represent the respondent, the U.S., in the case of Carpenter v. United States. The U.S. argued that obtaining Carpenter's cell site location data under the Stored Communications Act of 1986 was legal and did not require a warrant. Carpenter had no reasonable expectation of privacy in records held by phone companies, so that the data held in order to link him to the robberies did not violate the Fourth Amendment.
Question of the case. Does the warrantless search and seizure of cell phone records, which include location and movements of cell phone users, violate the Fourth Amendment? We, the respondent, the U.S., argue that the warrantless search and seizures of cell phone records does not violate the Fourth Amendment because records are business records that belong to the phone company, not the individual user. Under the third-party doctrine, when people share information with a company like cell site data, they cannot expect full privacy.
The first precedent case we would like to bring to the court's attention is Smith v. Maryland in 1970. It's not clicking. The first president case we would like to bring to the court's attention is Smith versus Maryland in 1979. This involves a third-party doctrine, which the police went to a third party, which is a phone company, to obtain a pen register, which is a document full of cell numbers that a suspect has dialed. The Supreme Court determined that the use of a pen register to record telephone numbers dialed from a user did not constitute a violation of the Fourth Amendment. Court reasoned individuals do not possess a reasonable expectation of privacy concerning numbers voluntarily disclosed to the telephone company. Not dialing numbers essentially gives up and exposes this information to third parties and the law enforcement. This case clearly supports the side of the U.S. the respondent.
Our second precedent case is U.S. vs. Knotts. In U.S. vs. Knotts, police placed a tracking beeper in a container with the seller's permission because they suspected illegal drug making. Officers used the beeper and visual surveillance to follow the container from Minnesota to Wisconsin on public roads to Knott's cabin. After the tracking, police got a warrant and found a drug lab in Knott's cabin. Although a lower court said that the tracking violated the Fourth Amendment, the U.S. Supreme Court disagreed. The court ruled that it was lawful because people have no reasonable expectation of privacy while driving on public roads, and the beeper helped officers follow movements they could have observed visually.
The government lawfully used the Stored Communications Act of 1986 to obtain 127 days of Carpenter cell site location through a court order based on reasonable grounds. Reasonable grounds is a standard designed to balance privacy with investigative needs. This helps link Carpenter to the case where he got caught. In the case of U.S. v. Miller in 1976, it was established that information voluntarily shared is not protected by the Fourth Amendment and allows the government to access direct records held by service providers without a traditional warrant.
Furthermore, all these precedent cases that were just stated all have a connection to U.S. or Carpenter versus U.S. For Smith versus Maryland, they use a third-party doctrine for both to obtain a pen register. For the U.S. versus Knotts, they both use public resources. In the Knotts case, they use public surveillance cameras to find where this guy went, which were public to everybody. And the Stored Communications Act connects to Carpenter versus U.S. because they got a court order that replaces a need for a warrant.
Thank you. These three precedent cases support our respondent side, the U.S. We urge you to uphold the lower court ruling.
Thank you, counsel. With the sort of increasing information, talk about a pen register that comes from an era where the only thing we'd know is the number and maybe who the owner of that number is, but not who on the other end of the phone is. Can you make a more direct connection there? Isn't it a little different to know somebody's location every, maybe 5-10 seconds versus just a number that's called, but nothing about the nature of the communication once the number's dialed?
Can you restate that, please?
Yeah, so I guess I'm struggling with the pen register just says, here's a number that's dialed, but not much more. The location data says, here's your physical location probably every 5, 10, 30 seconds. It seems like there's a big difference between those two. You're arguing there's not. Why is there not a difference?
I believe there's not a difference because you still have information of like who you're calling, correct?
The pen register would, yeah.
Yeah.
Other questions?
Can you explain to me why it's unreasonable to ask for a warrant? I mean, if there is really a suspicion that someone has committed a crime, why would it be inappropriate, or why not ask a judge for a warrant?
As we stated, it was a court order ruling, so the judge said that it was okay that we didn't have a warrant because it fell under the Sword Communications Act, which said that if the government needed any of your information that you voluntarily shared with this company, that the company could give it to you to help connect you to the crime.
One of your arguments was about public roads, so it was unreasonable to, I mean, they should be able to search on a public road. But if a police officer pulls somebody over and suspects a crime, drug possession or whatever it is, can they not search their car also on a public road?
No, because that's inside their car, and they cannot go inside their car without a probable cause or a warrant.
So they can go inside their cell phone but not their car?
We did not. They did not go into his cell phone, but obtained his cell phone records through the third-party company, which is given up voluntarily, and we use public cell towers to find locations of where Carpenter was.
Rebuttal by the petitioners, please.
Our responders said something about how getting somebody's phone number through who they called is just the same as tracking somebody's location, but they tracked Carpenter's location for 127 days, which showed a lot more about where he went, who he met, than who he called ever could. I know me personally, I don't call a lot of people, so I think that the location data points that they got in the 127 days was more than what his call logs could have been. They also had 127 days to obtain a warrant. If they would have obtained a warrant, and I think that at 30 days to obtain a warrant, they could have had more stuff they could have searched.
Wouldn't have getting a warrant tipped off Mr. Carpenter that they were trying to figure out what he was up to, though?
Yes, but I feel if they had a warrant, they would have been able to find him either way, and I feel like it would have took less time. And then they also wouldn't be tracking his private movements. Then they would have a warrant, and it wouldn't be private anymore because they went through the court and got a warrant.
Thank you, petitioners. Respondent, rebuttal, please.
The petitioners had a case where it talks about, in the Jones case, where it talks about how they use a beeper inside the car. And this does not relate to the Carpenter case because there is no third party involved. So,
They also stated that that Carpenter voluntarily shared this information, so it doesn't matter how far back they went into his phone because he voluntarily shared it with a third party, which was legal due to the Sword Communications Act.
But shouldn't the holder of the cell phone have some reason to believe that just because they were willing to perhaps share this data with a business that's not a government actor, that they didn't really give consent to share it with the government?
Can you restate that, please?
Sure. So I agree to share my cell phone data with the cell phone company, but I don't agree to share it with the government. What makes it so that the company and the government can get together and take my data without my consent to give it to the government?
Like we said, it's just the Stored Communications Act. When you're agreeing to give your information to your cell phone company, they are agreeing to give it to the government if it's needed for the purpose of a crime.
Thank you, respondents. The matter of Carpenter versus United States is submitted. Thank you, counsel. The court is now prepared to hear arguments in the matter of Morse versus Frederick. Petitioners, you may proceed.
May it please the court, I, Trinity Vanderschaff, am here today with my colleague Elizabeth Klein in order to argue in favor of Morse in the case of Morse versus Frederick. We have come to an equally reciprocated consensus that the petitioner Morse is in their judicial and constitutional right for the punishment and suspension of the respondent Frederick.
In 2004, Joseph Frederick, as well as the rest of his school community, went out to watch the Olympic torch running event. During the event, as the cameras panned by, Joseph Frederick, as well as several of his students, unrolled a banner reading "Bong Hits for Jesus." Once the principal of the school saw this, she went over to them and told them to take down the banner. All students complied except for Joseph Fredericks, who instead decided to quote his First Amendment right to freedom of speech, leading to a 10-day suspension. He then decided to sue the school.
The question presented in this case is, does the First Amendment allow public schools to prohibit students from displaying messages promoting the use of illegal drugs at school-supervised events? The following precedent cases we are brought to the table today are Hazelwood v. Colmier, 1988, Bethel v. Fraser, 1986, and Vernonia v. Acton, 1995.
I raised to present my argument on behalf of the petitioner, Morse. During the events that took place, Joseph Frederick was not technically standing on school grounds, instead breaking school rules to go stand across the street on the sidewalk, leaving up to question on whether he is actually attending school, and if his lack of attendance means the school cannot discipline him as a student. To combat this claim, I would like to bring forward the case of Hazelwood versus Coolmere from 1988. Now, during this case, it is talking about
a school newspaper and what a school can do in limiting speech within a school newspaper. But during court, it took a turn, instead going to school-sponsored activities as a whole, coming to the conclusion that schools can take steps to limit speech within school-sponsored activities. And both the District Court and the Ninth Circuit Court of Appeal agreed that this Olympic torch running is a school-sponsored activity, and Joseph Fredericks was in fact attending this event, meaning the school has every right to discipline him as a student, just as they would as if this had happened inside the school gym.
Furthermore, I would like to present the case of Bethel versus Fraser in 1986 for the idea of declarative implication. In Bethel versus Fraser, there was a speech given at a high school assembly, and I would like to take at least 10 seconds to read through the excerpt quickly. Now, the court ruled in the favor of the school that the text given was vulgar and lewd and set a new precedent that vulgar and lewd text can be restricted by the school. However, as you're reading the text, you may know that nothing is ever explicitly said. It is all implied language and is using words that are not direct or are directly affiliated with anything that would be of negative connotation. In the Bong Kids for Jesus banner, it is a declarative sentence by English terminology, meaning that it is a statement, states an opinion, or it just conveys information. In the Bethel versus Fraser speech, it was all declarative despite the imperative connotation that the whole speech had in itself. Therefore, Bethel versus Fraser and Morse versus Frederick align in the sense that the text on both instances can be restricted by the school. Bethel versus Fraser was vulgar and lewd, however, Morse versus Frederick included drug paraphernalia, which we will get to in the next slide.
Drug misuse is one of the most pressing issues of today's society. In 2006, DAWN, the Drug Abuse Awareness Network, did a study showcasing that 1.7 million emergency room visits every year is due to drug misuse or abuse. That is 1 in 175 American citizens. Veronian versus Acton from 1995 is a case about drug testing students within a school. And throughout trial, they came to the conclusion that schools can take protective measures to keep schools a drug-free environment per their student safety. We respectfully request the court to consider why it is so important for schools to be able to dictate what students can and can't do in regards to drugs. The student-to-teacher ratio is getting further offset every year. As of this last year, it was 15.5 to 1. Now, with the influx of students coming into our school districts, this number is only going to increase in difference. That is why we need to be putting these protective measures in our schools to keep our students safe. Our teachers cannot get the personal connections with students they used to in prior years, making it easier for things like drug addictions to occur. This is why, if the court allows a student to go unpunished, they are setting a new precedent. A precedent that drugs are a laughable matter, not something to be taken seriously, something to joke about in a school hallway. Is that the precedent we want to be setting for our future generations of America?
Mr. Chief Justice and Associate Judges, I implore you to consider taking the side of the petitioner Morse and Morse versus Frederick. We have covered Hazelwood versus Colmier in 1988, which confirmed that school-sponsored events can be regulated by the school. Bethel versus Fraser, that regulates implied nature of language, and Vernonia versus Acton in 1995, which helps to prevent students with drug usage. As my colleague has stated previously, drug misuse within teenagers is never going to end. However, we can help try to wean it off at the source by making it not a jokeable matter, by setting a new precedent that it is not okay and that we should be protecting the pedigree of America. I thank you for your time and your consideration, and I'll yield the floor to my opposing counsel.
Thank you, counsel. Questions from the panel? So the Hazelwood case, the court talked in some detail in that case about the speech bearing the imprimatur of the school. In other words, speech that someone could reasonably perceive that the school is making. How is it that a student holding up a Bong Hits for Jesus sign, anyone could perceive that the school is holding up the Bong Hits for Jesus sign?
So, first off, there's a consideration that during the events, one of the students was in fact wearing a school shirt. So as you can see him standing up, he is the one in the gray sweatshirt near the corner of the screen, and he is wearing a school sweatshirt. And as the camera's panning over, it is first off showing affiliation to the school due to that sweatshirt, as well as the fact, as being a student of the school, you are automatically a representative of your school. You signed up to go to the school, your parents signed you up as a kid, and you are a representative of your school whether you like it or not.
So how is it that saying bong hits for Jesus promotes drug use? I mean, I understand that there's a reference to a drug in the sign, but it doesn't say taking drugs is good or I want drugs or anything like that. How is it not just ridiculous?
It is in itself ridiculous, but that doesn't make it any better due to the fact that it's still promoting the use of drug usage in the way that it is declared. It is not exactly telling you to take a bong hit for Jesus. However, it is still mentioning drug paraphernalia within a school setting, which, as stated by Veronia versus Acton, we are trying to prevent in our students. So basically mentioning it whatsoever in this kind of connotation, we believe it's still not right. If it's not in a negative connotation, it shouldn't be mentioned at all.
Can the sign be interpreted in any way in advocating for the legalization of marijuana?
We would have to look further into that of the current state of the Alaskan law on marijuana. However, these were high school students, so therefore they wouldn't be able to engage in that activity anyway.
The First Amendment defends our right to protest the government. How is this not protesting the law that the government made? I mean, even if we agree with the law or disagree with the law, how is this not a protest? And therefore falling under First Amendment protections.
Protests themselves are cut and clear, and they want to push for an objective. So I personally believe that because there is no call to action within this sign, there is no reason for it to even be connected to that, especially with the mention of a religious figure. I personally do not believe that this is a protest due to the fact it's not acting for a call to action, rather just a statement.
Thank you, petitioner's argument from the respondent.
The First Amendment protects the right to the freedom of speech. Does it allow a principal to prevent a student from displaying a message that the school disagrees with, even when it doesn't take place on school grounds? When Principal Moore suspended Joseph Frederick for displaying his Bong Hits for Jesus banner, she violated his First Amendment rights because he was 1, not making a substantial disruption to school activities, 2, not physically located on school property, and 3, making a nonsensical but protected political statement.
Frederick, a high school senior in Juneau, Alaska, displayed a banner reading "Bong Hits for Jesus" from a public sidewalk as the Olympic torch relay passed by. He was not on school property, and he caused no disruption to school activities. By suspending him for a vague and absurd message, Principal Morse overstepped the limits of school authority and infringed on Frederick's fundamental American right to free speech.
The case that most aligns with this case is Tinker v. Des Moines, a Supreme Court case in which the Supreme Court ruled that students do not shed their constitutional rights at the schoolhouse gate. Students wore black armbands to school in protest of the Vietnam War, and the court ruled in favor of the students, saying that all student expression is protected unless it causes a substantial disruption to the functioning of the school. This became known as the Tinker Standard. One of the best ways that the Tinker Standard has been applied is in the case of Thomas v. Board of Education, a Second Circuit case from 1979, where students published a lewd school newspaper, mostly off campus, with help from a teacher. The school claimed that the newspaper was shocking, vulgar, and filthy. The court ruled in the students' favor, saying that student expression is not punishable unless it creates a substantial disruption. The court should adopt the reasoning of the Second Circuit and uphold the lower court's decision in this case.
The circuit court has already sided with Frederick, ruling that his banner was protected speech under Tinker because it caused no substantial disruption. In fact, the principal disruption was the principal herself running across the street to snatch the banner. The court reasoned that simply interpreting the phrase "bong hits for Jesus" as a pro-drug message was not enough to justify censorship, especially when no evidence showed that it encouraged illegal conduct or caused a disruption. Under Tinker, students do not shed their right to free speech at the schoolhouse gate. If the court decides to not rule in favor of Frederick, Tinker's precedent of student free speech collapses into a rule that protects only speech that schools agree with. Frederick's banner was an off-campus, non-disruptive statement that the Ninth Circuit rightly recognized as the kind of protected expression the First Amendment is meant to defend. Although the school claims authority over student conduct, Frederick's banner was displayed off-campus during a public event, protecting it as off-campus expression. In Thomas, the court ruled that students couldn't be punished for publishing material created off school grounds that did not cause a substantial disruption. In the same way, Joseph Frederick held his banner from a public sidewalk. He caused no disruption to learning. Like the students in Thomas, Frederick exercised his right to free speech, which makes his punishment a violation of the First Amendment.
Not only was Frederick's banner off-campus and non-disruptive, it was also protected political speech under the First Amendment. This court can affirm our client's position in two distinct ways. First, that Frederick's banner was protected political speech, and second, that the banner was nonsensical, simply an example of teenage attention-seeking. Either of these two paths is sufficient on their own, and together they make our client's position unmistakably clear. First, the banner could be seen as a call to legalize marijuana. If this is true, the speech is political. Based on Tinker, as well as numerous other circuit cases, such as Burnside v. Byers and Giles v. Marino, political speech is especially protected above all other types of speech, and the court should rule in our favor. Even if the argument for the speech being political does not hold, the court should still rule in our favor based on Frederick's motivation. According to Frederick himself, he was just trying to gain attention with his nonsensical banner. The Olympic torch relay was being televised. Being on television is at least as valid of an explanation for the banner as promoting illegal drug use.
At its core, Morse v. Frederick is about the right of a student to display a banner, no matter the content. Joseph Frederick stood on a public sidewalk, disrupted nothing, stood on a public sidewalk, and expressed himself in a way that tested the boundaries of school authority. Punishing him for a harmless off-campus statement turns the First Amendment into a tool for enforcing viewpoints rather than protecting ideas. Allowing Frederick to hold his banner ensures that even the controversial and ridiculous remains part of the public conversation, and that students can think, question, and speak without fear of arbitrary punishment. If the First Amendment cannot protect a silly banner, it protects nothing at all. Thank you.
Thank you, counsel. Does it matter that the attendance at the Olympic torch relay was something that was permitted by the school, that occurred during school hours, that it was supervised by the school? How does that factor into your analysis?
So Frederick hadn't even stepped foot on school grounds that day, actually. He came directly from home and went to the school event. He just happened to be standing by his friends. The other thing is that it didn't physically take place on school grounds, so we don't feel that the school had the authority to regulate that.
Who decides what caused a substantial disruption in the school setting?
In the Tinker standard, it's just a reasonable person could see a substantial disruption.
Would a principal be a reasonable person?
I think so, but the circuit court has already ruled that it wasn't a substantial disruption, so the circuit court is also reasonable people.
So by attending a public school, would you agree that you are maybe upheld to a certain code of conduct even when you are not at school?
I think that might apply more to a private school. There are codes of conduct, but free speech is protected by default unless it causes substantial disruption. So the Tinker standard is pretty clear.
You said a couple of times that his statement was a nonsense statement. It clearly was meant to communicate information. It might be absurd, but it wasn't nonsensical. In fact, wouldn't it be stronger to suggest that it was nonsense, then it's not speech to be protected because he's not making a statement, for example, against the government.
Well, we also said that the speech could be interpreted as political. He himself said that he meant it as a nonsensical statement. Yeah, he was just trying to get on TV. I don't see that. I think the speech should be protected either way, whether it was political or nonsensical.
If there are no further questions from the panel, then we'll move to rebuttal by the petitioners.
We would first like to bring up the argument of it being non-disruptive. Throughout the event, it has been stated several times that he is seeking attention. How can you be seeking attention if you are also trying not to be disruptive and cause a disruption? I want you to imagine what happened in the classrooms after this event took place. Do you think the students all went straight back to listening to the teachers as they tried to teach a lesson, math, English? No, they went back to the classroom discussing the event that went on, making it harder for teachers to teach students about things that they are needing to be learning in a school, instead focusing on a message they saw outside of school by one of their classmates. There's also the issue of whether location again, and I want to further state the fact that it was a school-sponsored event, and both the District Court and the Ninth Circuit Court of Appeal agree that it was a school-sponsored event, and that Joseph was in fact attending, and coming in and joining his classmates who had all been attending school and going into the community of the school is bringing him into attendance of the school, but also the fact that attendance was not needed as he's a representative of the school no matter what.
And furthermore onto that, if you are to attend a football game or a basketball game and you're being disruptive, your school does have the right to discipline you for that action. We had that instance in ourselves when we got in trouble for volleyball chants at a game. Now, furthermore onto that, when they bring up Tinker was very obviously a protest. That cannot be denied due to the fact that they were armbands. They stately and very imperatively told their issue about the Vietnam War. In this case, Bong Hits for Jesus is a simple statement that really is not supposed to go anywhere, but can still have a negative effect on the youth and the impact of the pedigree.
So, but the armbands in Tinker didn't say anything, right? They were just black armbands. So how are those clearer or not clearer than something that's occurring here?
Well, then I have a question for you. How do we know that it's the Vietnam War? They stated it very clearly if they were just black bands, because then they would have to exactly say what they were for, and they were very clear about that matter.
You're calling public school kids representatives of the school. I understand if you make a contract with a private school to attend, that's voluntary, but children who do not attend a private school are obligated to go to school somewhere. So public school is obligatory. If they're forced to go there, can they then be legally forced to be representatives of a place that they're forced to go to? I mean, I understand if you're voluntarily choosing to be a representative of something.
I want to bring up the fact that in America, if you are born in America, you're an American citizen, and you are required to follow the laws of America. Just because it was required does not mean that you do not need to follow the law. You have to go to school, yes, but you also have to follow the rules and the laws within a school. And when you are put in that school, you agree to follow those rules, whether you have a choice to go into that school personally or not. You can choose what school you go into, but you have to follow the rules of a school as a student.
The school's rules have to lead to yield to the supreme law of the land, right? The Constitution. I think that's what we're trying to understand here is if the school made a rule that said students can't say anything anywhere, that law is patently unconstitutional. So how do we square those two things here?
We square them by the disruptiveness that it does cause in the students and how it can affect our pedigree and our future generations. As stated by Hazelwood and Colmier and Bethel versus Fraser, we are trying to avoid negative impacts on the future of our children. Therefore, I do believe that this is a case that can be restricted due to it promoting drug paraphernalia.
What about a student that makes an edgy social media post? Are they considered a school representative at that point, being in the public sphere as these students were on the side of the street?
They are punished severely for that. People have gotten in trouble for making edgy posts about school shootings, about bringing certain weapons into school, that they are still representative and they do get punished for that, yes.
If a student made a long reference on social media, should they be disciplined for that?
While the event is definitely something that should be looked into deeply, which we have not prepared to look into, I do think it is a matter to take into consideration, but it is not as closely connected with the school, so it is definitely a different issue that could be handled differently with a different conclusion.
Are students always representatives of their school?
I believe, yes, they are indeed. Yes.
And that can be proven further by getting in trouble at parties, or even like your teacher catching wind of you doing illegal activities. They are legally obligated to report that. So I do believe that you are held to a certain standard of responsibility and connection to your school.
Thank you, petitioners. Rebuttal from the respondent.
Your Honors, the First Amendment does not soften the second a student steps near a school-supervised situation. The banner is nakedly nonsensical, and no disruption was caused regardless of any reasoning respecting drug use. Tinker makes no reference to illegal activity, only substantial disruption, and this banner caused none. Giles v. Marino props up that principle. The court let a student don duds adorned with depictions of drugs because it was political speech that caused no substantial disruption. If that on-campus speech remains protected, Frederick's off-campus banner deserves protection all the more. Frederick was late to school. He hadn't even set foot in school when he held his sign that day. Punishing off-campus proclamations pushes a principal's power past its proper periphery. Crushing Frederick's cannabis commentary corrodes the careful confines created in Tinker. Kids keep their constitutional cloak unless their content conjures concrete, consequential conflict. Crucially, this speech did not. For these reasons, we respectfully ask the court to affirm.
Isn't there some ability for the school to sort of make a reasonable decision that speech isn't really political and isn't doesn't add value to the national discourse, and kind of make that decision? Shouldn't we give the school some flexibility there?
I think there are plenty of things that students say that don't add to the value of the national conversation, and as long as they don't cause a substantial disruption under Tinker, they should be allowed.
If there are no other questions from the panel, we'll consider the matter of Morse versus Frederick submitted. Thank you, counsel. Court is now prepared to hear arguments in the matter of Navarrete versus California. Petitioners, you may proceed.
May it please the court, I'm Colby Hartog here with my fellow co-counsel, Kato Manscapin and Orion McDonald, and we represent the petitioner Lorenzo Prado Navarrete in the case of Navarrete v. California. The question of the case, does the Fourth Amendment require an officer who received information regarding drunken or reckless driving to independently corroborate the behavior before stopping the vehicle? We, the petitioners, argue yes, that without independent corroboration, the traffic stop violated the Fourth Amendment right of Lorenzo Prado Navarrete.
The case began when police received an anonymous tip that a vehicle was swerving on the road and ran somebody off the road. The officer located the exact truck, followed it for 5 minutes, and witnessed no erratic driving or traffic violations. Even though he witnessed nothing suspicious, he still pulled him over based on the tip that was already disregarded when he followed him for 5 minutes and there were no violations. Upon questioning Prado Navarrete, he suspected the scent of marijuana. During the search, he found 30 pounds of marijuana in the truck bed of the pickup.
To begin, on the side of the petitioner, the police officers failed to corroborate any sort of illegal activity after pursuing the vehicle, despite verifying the exact Ford F-150 with the exact license plates match. I'd like to direct the court's attention to the case of Florida v. JL. This is a pivotal case because the courts voted in favor of JL, who was tipped in anonymously and illegally searched for illegal weapons at a bus stop. The tip only included his shirt color and the weapon he was carrying. When the police arrived, they failed to corroborate his name and identify him completely before arresting him. The courts ruled that a police officer may not legally search and frisk someone based solely on an anonymous tip, but it must be corroborated by themselves. In the case of Navarrete versus California, the police officer received the tip at 3:47 p.m. He then drove to a 69-mile marker where he parked and viewed Navarrete driving past in his truck at 4 o'clock p.m. This is when he pulled out and began his 5-minute pursuit. During the 5-minute pursuit, he saw zero signs of erratic driving or illegal activity, yet still proceeded to pull him over at 4:05 p.m. Because the officer decided to follow Navarrete instead of pulling him over immediately, the tip was no longer valid in the case. This would mean that the officer has to corroborate the information for himself and see some sort of illegal activity or erratic driving with his own eyes, not relying on the tip anymore that is no longer valid. Because he failed to do this, the traffic stop that occurred was illegal and should have never taken place. Your Honors, the police officer not only failed to corroborate the tip and view any illegal activity, but also violated Navarrete's Fourth Amendment right by lack of reliability from the tip.
Furthermore, the anonymous 911 call in Navarrete v. California did not have the reliability to justify a stop under the Fourth Amendment. I'd like to cite the case Alabama v. White as a persuasive authority because it is a pivotal case in determining whether a tip can be considered reliable or not. The police received a tip that White would leave her motel room at a specific time, get into a specific car carrying cocaine. Based on this tip, the police were able to locate her and stop her. In Alabama v. White, the Supreme Court ruled that the tip was reliable if it gave predictive information. In Navarrete v. California, it only gave past information and no future actions were in the tip. This shows that the tip in Navarrete v. California was weaker than that of White and did not give reasonable suspicion. I would respectfully request that the court consider the lack of predictive information in the 911 call make it unconstitutional to stop Navarrete because it did not give any future actions that were witnessed by the officer.
The case I would like to cite is Aguilar versus Texas. In Aguilar versus Texas, the Supreme Court ruled that a search warrant based on an informant's tip is invalid unless the affidavit shows both the informant's credibility and the reason for their knowledge. Because the affidavit failed to reach these requirements, the court sided with Aguilar and found the warrant and the evidence obtained invalid. This case sets a precedent for the case of our case, Navarrete versus California, because it establishes that police must have reliable and well-known information before taking action upon someone. In Navarrete, officers received only a vague and anonymous 911 call that had limited detail and no way of knowing whether the caller was reliable. Police then followed Navarrete for 5 minutes and saw no illegal or reckless driving, which undermined the credibility of the tip. Since officers never confirmed the caller's claim, the stop lacked the reliability and the verification that Aguilar required. Overall, Aguilar versus Texas reinforces the idea that anonymous tips must be credible and independently confirmed, directly supporting Navarrete's argument that police didn't have enough reliable information to justify the stop after following Navarrete for 5 minutes and no corroboration after first seeing the vehicle.
As the petitioners, we implore that this court uphold the principles of justice and fairness. Navarrete versus California goes to show that relying on an unreliable tip solely without corroboration is a violation to Americans' Fourth Amendment rights. This is shown in the case of Florida versus JL, that an unreliable anonymous tip is not enough to corroborate a police stop.
Second, in Alabama v. White shows that there needs to be specific predictive information that were not included in the tip in Navarrete v. California.
Lastly, in Aguilar v. Texas, it shows the police must show both the informant's credibility and the reason for their knowledge before using the tip as evidence, which clearly was not carried out in Navarrete v. California.
This goes to show that protecting citizens and
questions from the panel. Wasn't the tip sufficiently detailed here, though, that it very clearly described the car and how things were happening with the car that gave the police enough to pull over the car, even if they themselves didn't see any illegal behavior?
Yeah, so they gave an exact description of the vehicle, the color, the license plate, all of those types of things. However, if the police officer wanted to pull over Navarrete based on the tip, then he would have had to pull him over immediately, because the second he started following him for 5 minutes, the anonymous tip was no longer valid, and now this was on the police officer to corroborate the tip himself.
But why should we hold that just because the officer does more investigation that changes the validity of what was said previously?
Because as soon as he starts following him for 5 minutes, he needs probable cause and not reasonable suspicion anymore.
And this is something that he completely lacked, because the anonymous tipster called in that the truck ran him off the road once and he was worried about the safety of others. However, once the cop pulled out behind him, he didn't see any signs of erratic driving at all. So the truck was completely driving normally and legally, and he still performed a traffic stop. So that's why it was illegal.
Let's say that the tip was, hey, I saw a guy running out of a bank with a mask and 2 money bags jumping in the car. And then the cop follows him, and he doesn't see the guy running around with money bags because there's a cop following him. I mean, you would expect a difference of behavior in the presence of a police officer. So why would the expectation be that he has to also perform the same illegal act in front of a police officer that he had been doing before?
I believe that this is a different situation in the fact that the tip included, the only thing about the tip was that the truck was swerving him off the road and running him off the road. In that situation, it would be a crime that was happening, and I don't think that they would have to corroborate the illegal activity on the road because it wasn't a tip about his driving.
But it's threatening behavior, running someone off the road. I mean, it's not just I'm swerving, maybe I'm effectively drunk driving, but threatening behavior. If somebody was threatening somebody with a knife and then the police officer came and he had put the knife away and wasn't threatening someone, I mean, again, could you search the person under that suspicion?
Yeah, well, that is understandable. The running off the road, it only happened once, and it was just a swerve, so I think that it may not have been intentional. It may have been like a distraction, and they may have gotten out of sorts with the driving. I don't think that it was an intentional thing, so.
Thank you, petitioners. Respondents?
Mr. Chief Justice, and may it please the court. My name is Jackson Kaiser, and I'm here with my co-counsel Carter Klein-Waltering. This case is about protecting public safety. A 911 call reported that a trucker ran another car off the road. The police quickly matched these details with the truck and pulled the truck over in order to protect public safety. The Fourth Amendment talks about preventing unreasonable search and seizure, but it doesn't talk about preventing police from acting on a reasonable tip in order to protect public safety. For this reason, we ask that you may side with the state of California and find that the police officer's actions were lawful under the Fourth Amendment.
The police action here was perfectly reasonable under the Fourth Amendment, and this was not just a random stop. It was an act of public safety. The officers had credible and reliable information. A 911 call reported an active, life-threatening felony, a truck driving another car off of the road. Crucially, the caller gave specific, verifiable details, including the exact license plate and location of the car, as well as the model and color. This established the tip's credibility, and the officers verified these facts and acted immediately to prevent a greater tragedy using all the information from the call. Therefore, the stop was constitutional, and we urge the court to affirm the lower decision.
The constitutional question is, does the Fourth Amendment require an officer who received information regarding drunken or reckless driving to independently corroborate the behavior before stopping the vehicle? When officers acted on the specific verified information from the 911 caller, they acted lawfully to preserve public safety. To understand how this question applies, we must look closely at the facts that gave rise to the stop in this case.
In this case, the 911 caller gave very specific information about a silver Ford F-150 that had run her off the road. The officers found the truck with the exact license plate shortly after and made the stop. During the stop, they smelled marijuana and discovered 30 pounds of it in the bed of the truck. The defendants argued that the stop was unconstitutional because the tip was anonymous and that they had not witnessed it themselves. Looking at these legal precedents will help us to verify the court's decision.
In Ounce v. Williams, the key point was that the police verified the crucial details of the tip. The officer received specific information about an armed suspect and confirmed it by finding the gun. This connects to Navarrete, as the tip was anonymous. Even the officers were still able to verify the important details, the truck's make, model, and the direction as the caller reported. Because the tip was through the traceable 911 system, it carries additional reliability. When we apply these precedents to the facts before us, it becomes clear that the officers acted on a reliable, traceable report with legitimate concern for public safety.
In Illinois v. Gates, the Supreme Court said that when public safety is at stake, officers can act on a tip as long as the details seem reliable under the totality of the circumstances. In Gates, the police received an anonymous letter about drug trafficking and confirmed enough specific details to justify the immediate action. Even though in both cases the tip was anonymous, it had enough evidence to become a reliable source. The main point here is that a public safety concern supported by verified details justified the immediate stop.
One key precedent that can be shown is that an anonymous tip can give reasonable suspicion for a traffic stop, as this is shown in Alabama v. White. In that case, police received an anonymous tip predicting a woman's route and saying that she was carrying drugs. Officers confirmed specific details before stopping her, and the Supreme Court ruled that even though the tip was anonymous, the accuracy of its predictions made it reliable enough to justify the stop. In Navarrete, the 911 caller provided detailed information about the truck and the dangerous event they personally experienced. Officers confirmed those details before acting. Likewise, the reasoning in Illinois v. Gates further supports the officers' actions through its totality of the circumstances approach.
The 911 call wasn't just a vague claim. It was detailed and traceable. Police verified the truck's description and license plate before making the stop. Given that the report described a driver who had nearly caused an accident, it was reasonable for officers to act immediately to protect the public. The stop was not random. It was based on solid, confirmed evidence. For this reason, we ask the court to side with the state of California and affirm the decision of the lower court.
Thank you, counsel. Questions?
Would you say that, in my opinion, I wonder if the driving erratic is kind of up for debate. You know, is that in the wrong lane? Is that near the center line? You know, versus some of the other cases of, you sure the person had a gun? You know, those are very black and white things, where I would argue maybe erratic driving is maybe more debatable. What would you say to that?
On the call, she reported that it had almost ran her off the road. If you were in her spot, wouldn't you want something to be done about that? You wouldn't want the driver just to go away without anything happening to them.
Why not require the officer to follow them for longer? What about the petitioner's claim that essentially the 5 minutes that the officer viewed, there wasn't any erratic driving, and with it being an anonymous tip, how do we know there wasn't just somebody that was trying to get the person in trouble? How are we able to verify the actual criminal part of the tip versus it's this car?
The call was traceable, so they'd be able to go back and look at what was said. And we think that as soon as like you see a cop following you driving, you're obviously going to be more well behaved. And we think the longer that they follow them, they would just stay in their lane and not obviously try to run someone off the road when a cop is following them.
If a search and seizure can be based on just a single tip, doesn't that make the system vulnerable? Because any police officer that wanted any excuse at all to search anybody could just have somebody call in, and then they would have all the excuse that they need. Doesn't that open the whole system to abuse?
Yeah, we could see where that could happen, but they had enough reasonable evidence and multiple points proving that this was something that was happening and that was true. So it wasn't just one tip that was given, it was multiple points.
So there were multiple calls in this case on the erratic driving?
No, there was one call, but there was multiple points that were proved that there was bad driving.
How so?
Well, they gave like the specific location, what was happening, and like where they were going, as well as like the car, the license plate, and like the color.
I agree with my Associate Justice Uncle that your case really doesn't establish verifiable details beyond the car, make, and model. One person reporting an incident doesn't actually confirm the incident took place.
Yes, but if there was nothing that would happen, they would, and he stopped them, they would be able to quickly realize that nothing would probably happen. But once there was marijuana in the car, they probably would realize that something else was going on.
Sure. I'm referring to the event of someone accusing this vehicle being driven off the road. People make false 911 calls all the time, and based on a single call, it's not enough to establish the credibility that a violent, intentional act of driving somebody off the road actually takes place. That's all subjective.
When the police officer pulled the truck over, he probably got his side of the story, like when he talked to the driver. But then it ended up becoming more of a problem, obviously, because of the marijuana issue. I think he would have probably had, since there wasn't enough information necessarily on his side, or it would have gone to court like it did, it would have probably just gone off and he would have been able to drive away. But because of the marijuana issue, this obviously became a bigger scenario.
I'm simply just affirming here with Associate Justice Uncle that it doesn't seem to be enough to uphold an actual reasonable search.
Thank you, respondents. Rebuttal from the petitioners.
We, the petitioners, argue their main claim or their main point was that it was a public safety issue. But why, if it was a public safety issue, why did the police officer follow him for 5 minutes and not act upon it right away? Like if there was a danger or something and the police really thought it was a public safety concern, why did they not act upon the vehicle right away?
In addition to that, I think that the officer following him for 5 minutes kind of indicates that it wasn't as big of an emergency, because if the truck would have been running this car off the road like left and right, then he would have immediately acted on the tip. Also, I would like to mention, they said that something would seem reliable, that the tip seemed reliable, but seeming reliable isn't enough to protect others. Seeming reliable isn't really like a good argument, because it doesn't have any reliability. And the anonymous tip, like I said, was anonymous, so it could have been, they could have had the objective of pulling this guy over. It could have just been someone trying to get him in trouble.
Thank you, petitioners. Rebuttal from the respondent.
We found that when public safety is at stake, the officers can act on a tip as long as the details are reliable under the totality of the circumstances. And there was enough evidence for the call to be reliable because they gave the license plate, make, and model of the truck and the direction that it was going. And they also confirmed this evidence before the stop. And we found that the 5 minutes, they probably needed to check all the details that were given to make sure that it was the same car and person they were pulling over. And if this was you, would you not want to be protected from people driving like this or crimes, even though a cop doesn't see it actually happening? Because if this was happening, the amount of things that the cops don't actually see is way more than what they do see.
Questions? Seeing none, we'll see the matter of Navarrete versus California submitted. Thank you, counsel. All right, the court is prepared to hear arguments in the matter of Texas versus Johnson. Petitioners, you may proceed.
Mr. Chief Justice, and may it please the court, my name is Jacob Vanentop, and this is my partner, Kason Mulder. Today we represent the petitioner, the state of Texas, and we are asking the court to reverse Texas flag discretion law and show that Gregory Lee Johnson's act of burning the flag was conduct, not speech.
This case isn't about silencing speech. It's about protecting the symbol that unites us. The American flag stands for our history, sacrifice, and freedom. When Gregory Lee Johnson burned the flag in 1984, he wasn't expressing ideas but provoking outrage. Texas has the right to defend its flag's dignity and to preserve respect and order. Free speech does not include destroying the very symbol of that freedom. Texas acted lawfully to protect our values and unity.
The The constitutional question is whether state law prohibiting the burning of the American flag violates the First Amendment's guarantee of freedom of speech. The First Amendment protects freedom of speech, but not conduct, especially conduct that can cause public disorder. Texas argues that burning the flag is harmful conduct, not expression, and therefore can be lawfully restricted.
During the 1984 Republican National Convention in Dallas, Texas, Gregory Lee Johnson burned an American flag as part of a political demonstration, protesting the Reagan administration. Johnson was charged and convicted under a Texas statute prohibiting the desecration of a venerated object, which included the national flag. The Texas Court of Criminal Appeals reversed the conviction on holding that his conduct was protected as symbolic speech under the First Amendment. Texas appealed to the U.S. Supreme Court. Texas claimed that statute wasn't about silencing Johnson's viewpoint, but about the method he used. The state argued they would have charged anyone who burned a flag regardless the political affiliation.
Flag burning is conduct, not speech. In U.S. v. O'Brien, the court said the government had a significant interest in protecting the draft system. Draft cards help track registrants, verify status, and ensure the draft functioned properly. The law didn't treat O'Brien's message. It targeted conduct that would disrupt a crucial government process. Similarly, Texas law preserves the flag's integrity and prevents disorder. Just as destroying draft cards was punishable, burning the flag interferes with the government's legitimate interest in national unity. The court said the government can make rules about actions when it has an important reason, even if someone is trying to send a message. Texas is doing the same thing here. The law isn't about shutting people up. It's about protecting the flag and stopping fights or trouble that can break out when someone burns it. Texas is focusing on the action of burning the flag, not the person's opinion.
The American flag is more than just a piece of fabric. It represents unity and freedom for our country. Many citizens feel that burning the flag is deeply offensive because it attacks a symbol they respect and hold dear. In the case Texas v. Johnson, Texas argues that they had the right to protect the national symbol like the flag, and to preserve that respect and prevent any actions that could upset public order.
Texas law is neutral and prevents disorder. In Cohen v. California, the court ruled a man wearing a F the draft jacket was protected because he used words and not violent acts. Cohen's expression didn't disturb peace or destroy property because the First Amendment protects speech, even offensive speech, but not destructive acts or conduct. Burning the flag crosses that line.
This case is about respect for our nation and the flag that represents it. When Gregory Lee Johnson burned the flag, he wasn't voicing an opinion. He was trying to upset people. Texas did the right thing by charging him. We asked the court to reverse the ruling in the lower court in favor of Texas.
How do we know he was trying to upset people versus make a statement?
He was burning something that represented our country that a lot of people fought for, and there was no reason for him to burn the flag for what he was trying to argue.
Why would that provoke outrage?
A lot of people respect the flag and hold it dear, and he was burning what a lot of people respect, and I think they wouldn't have appreciated him burning the flag like that.
So he's sending a message of disrespect to the country.
I think so.
If it's a message, though, isn't that speech?
Not when you're destroying something.
Whose flag was it?
It was the American flag.
Right, but did he own the flag? I mean, was he destroying his own property, or is the issue here that he was destroying somebody else's property?
I'm not sure whose flag it was. Texas had a law on burning the flag, where I don't think anybody has a law about burning the Bible. So I don't think it would have been a crime necessarily to burn the Bible. I don't think it would be a bad thing if they made a law about that.
If there are no further questions, we'll move on to the respondent. Thank you, petitioners.
Your Honor, if it pleases the court, today my name is Aaron, and I'm here with my co-counsel Fatima and Sammy. Today we are representing Gregory Lee Johnson. This case is about whether the state can punish political expression simply because it is offensive. Burning the flag during a protest is symbolic speech at the heart of the First Amendment. Texas law targets Johnson's message, not any threat to the public safety. The First Amendment protects exactly this kind of unpopular political expression. The question that is in front of the court is: the First Amendment protects does burning the American flag as a form of protest count as protected symbolic speech under the First Amendment? We agree it does. Why? Because, Your Honor, the First Amendment isn't optional. It demands protection of political expression. The state cannot pick and choose which messages are acceptable. Johnson's protest falls directly under constitutional protection. Johnson didn't burn the flag for shock value. He delivered a clear political message. And, Your Honor, the state's job is to protect rights, not feelings.
Texas versus Johnson centers on the fact that the respondent burned the American flag during the Republican National Convention. He did this to exercise his First Amendment right of freedom of speech. This case was very controversial as many people found his actions very offensive, while others understood his demonstration of what he did was a powerful expression of his constitutional right of freedom of speech. I would like to address the attention to the case of Stromberg versus California. Was a pivotal case in defining this kind of symbolic speech because the Supreme Court ruled that displaying a red flag daily at a children's camp is a form of protest was protected under the First Amendment. In the context of Johnson's case, this demonstrates that the Supreme Court cannot punish someone simply because their opinion is unpopular or upsetting. Just as the court protected Stromberg's protest, Johnson's actions should be protected too, even if people were offended by what he did. Overall, this shows that symbolic protests have been protected before, and Johnson's case should also be treated the same as others.
The issue at hand as presented in the case shows how Spencer versus Washington case supports the idea that peace flag related protests are protected by the First Amendment. The court ruled that changing or displaying the flag as a form of expression is symbolic speech, especially when it communicates a political message. In this case, on the flag was with tape, they put like a peace signal. Besides emotional, a lot of people were offended by that. Nobody was harmed. It was just like the emotions from the people. Overall, this case with other cases supports the arguments that Johnson's actions were protected and safe under the Constitution.
Another important consideration is Street versus New York. Street versus New York is defining symbolic speech. In this case, a man burned a flag in anger after the shooting of James Meredith. The court took side with Street because the government cannot punish someone for expressing their opinion for even others find it offensive. In the context of Johnson's case, that means that burning the flag to express your opinion is a form of symbolic speech protected by the Constitution.
Both Street and Johnson's engaged in acts of protest that acted out as strong opinions, but caused no physical harm overall. Overall, the case of Street versus New York reinforces that Johnson's flag burning is a form of expressing political opinion.
In conclusion, the case of Texas versus Johnson clearly shows that burning the American flag is protected from a symbolic speech under the First Amendment. Johnson was not attempting to harm anyone. He was just sending a political message, and the Constitution gives the individual's right to do so. Each of these cases supports the idea of political expression even when it is offensive to others. It is fully protected by the First Amendment. Thank you, Your Honor. Thank you, Your Honors, for your attention and consideration. We are open to any questions.
Thank you, Counsel. Questions from the panel?
If I made a figure of someone that I didn't like, and I symbolically like murder, I cut the head off of the thing, something that could be perceived as threatening behavior, would that be unconstitutional, or would that be allowed as an expression?
I mean, well, what you said does go or follow what burning the flag. It's not about what, like you said, you cut the head off, and it does seem kind of threatening, but you're still expressing how you're feeling.
But in a flag burning, you're symbolically destroying something that symbolizes me and you and everybody else. You know what I mean? Does that cross the line into threatening behavior?
No, because in a way, nobody was really harmed. It was just you expressing how you feel towards that person.
Does the ownership of the flag matter in this case?
Not in this case. Not in this case, because we're not talking about if he stole the flag or if it was his own or where the flag came from. We're talking about him burning the flag.
Does it matter though if it was his flag versus if he was burning, a flag that was displayed by the public?
I believe not.
If you chanted death to America, would that be protected speech?
Yes, because you are saying what you think.
Even wishing the destruction of the country?
Yes.
We'll move to the rebuttal by the petitioners.
Your Honor, the opposing side said this case was freedom of speech, but we do not believe so. We believe this is conduct because he never talked about that he didn't agree with the Reagan administration. He didn't make a sign, but instead he burned something and had very bad conduct. And he burned the flag that people fought for and a lot of people respect in our country.
Isn't some amount of symbolic speech protected though? I mean, assume that I have a shirt that depicts something in protest. Wouldn't that be protected? Does it require words?
We believe so, as the First Amendment is freedom of speech, not conduct. And as you said, if you have a shirt with words on it, that is, we believe, freedom of speech.
Well, assume the shirt doesn't have words, it just has some sort of picture, or assume the shirt maybe has a picture of somebody burning the flag. Would that be protected?
Yes, we believe so because it's a political poster and he's not actually destroying something.
there are no other questions for the petitioners, then we will have rebuttal by the respondents.
As the petitioner was stating how the American flag represents a lot of what we have done for the U.S., yes, the flag was burned over, but this is also a form of freedom of speech.
So what are the limits then of freedom of speech? I mean, how does the court, is all speech protected? You know, the past precedents have said not, that if it causes a disruption or it incites violence or things like that. So how do we draw the line here?
I think that we can draw the line where if it starts putting the public safety at risk, I feel like that's where we have to draw the line. But as long as you're just expressing what you're feeling and you don't make it seem like you're trying to kill someone or, you know, hurt someone in a way, then I think that's where we can draw the line.
If there are no other questions, we will consider the matter of Texas versus Johnson submitted. Thank you, counsel. And we will stand in recess for a 10-minute break. The court will reconvene at 10:35. All right, the court is back in session and prepared to hear arguments in the matter of Florida versus Jardines.
Mr. Chief Justice, and may it please the court. My name is Kira Bogard with my partner, Mia Darnell. We represent the petitioner, Florida, and ask the court to reverse the decision of the lower court in our favor.
A dog sniff is not a search. The detective, along with the drug detection dog, only approached the front porch, which is accessible to the public. The dog sniff was non-invasive and was also non-disruptive. They did not disrupt the Jardines at the time of the sniff. There is also no expectation of privacy when it comes to the odors that are emitted to the public air from your home.
The Fourth Amendment protects people from unreasonable searches and seizures by the government. Its main purpose is to protect privacy in your home, especially. Police usually need a warrant signed by a judge to search your home. A warrant must be based on probable cause. Now, the constitutional question before the court is, does the use of a trained narcotics detection dog sniff at the front door of a suspected marijuana grow house constitute a Fourth Amendment search requiring probable cause? No. In this case, police were able to access the front porch without a search warrant because they had probable cause. They had received a tip, and anyone who walked up to the porch could smell the narcotics in the air.
In 2006, the Miami-Dade Police Department received an unverified tip that Jolis Jardines was growing marijuana in his home. This was not enough to gain a search warrant, though, from a judge. So, two detectives, along with a trained drug detection dog, went to the home of the Jardines and approached the front porch. The dog signed that it could detect marijuana, along with one of the detectives could personally smell it in the air. This was enough to now obtain a search warrant. They applied for one and got one from the court, and Jolis Jardine was arrested and charged with trafficking cannabis. Yes, the cops did use a drug detection dog, but a drug detection dog is not a search. In Illinois v. Cabal, the cops used a drug detection dog at a lawful traffic stop and found illegal drugs. The Supreme Court ruled this did not violate his Fourth Amendment right. The drug dog is only used to detect narcotics, not to search. And the dog sniff was not in his home.
The porch is accessible to the public. There was no fence or any other barrier that was obstructing the police from walking up to the porch. In the case California v. Serralo, police flew a plane over a man's yard. This revealed marijuana plants that had been growing in his backyard. The plants were visible to the public, so his Fourth Amendment right was not violated. Serralo's Fourth Amendment right was not violated because the drugs were able to be seen from above his home. The officers did not need to physically search his backyard. The dog that was used in the sniff was in no way going into the house, and therefore none of Jardine's items were physically searched.
There is no reasonable expectation of privacy in the odors knowingly emitted into the public air. In the case Katz v. United States, Katz was suspected of illegal gambling. For this gambling, he used a public phone booth. The FBI placed a listening device on the outside of this booth and listened in on his conversations. In our case, there is no expectation of privacy to the odors emitted into the public air, though. The use of the drug detection dog did not violate the Jardines' Fourth Amendment rights. The front porch was accessible to the public. The drug detection dog sniff was non-invasive and did not disrupt the Jardines. There's also no expectation of privacy when it comes to the odors that are emitted from your home. We please ask that you find in the petitioner's favor of the crime Mr. Jardines committed. The Fourth Amendment right was not violated with this dog sniff. Thank you, Your Honors, for your time and attention.
Thank you, counsel. Questions from the panel?
You use the word accessible to the public a lot, and I'm just wondering, like, at what point does that break off? Because, like, say the door's unlocked, well, that's technically accessible to the public, even though it's not their property, or the porch is accessible to the public, but the homeowners still have ownership of that. So, like, at what point is that violating of privacy?
So obviously, once you go inside of the house, that like without permission, that would be violating, like, because if you don't have permission to go into the home without the homeowner's permission, obviously, then that would be a crime. But going up to the porch, anyone can go up to the porch, like Girl Scouts, people that are trying to sell items, the mailman, and if it were like the mailman going up and that he could smell the narcotics in the air, hence that would be the odors emitted.
Is the front yard his property?
Yes.
So they were on his property?
Yes. But they didn't physically need to search. Because it could have been, let's say it was like the mailman walked up to his house and they can smell the narcotics in the air, and that's enough evidence for the probable cause.
Did the record say whether the police could smell it or only the dog? What if the homeowner had a fence or a gate that said, "Do not enter"? Would that have changed the analysis?
I would say so, because then there would be something that would visibly be stating or like obstructing the path from the police just walking up to the house, as if it were a random pedestrian as well. They wouldn't be able to walk up to the house because there would be an obstruction in the way.
So let's assume the sign says, instead of just "Do not enter," mailmen and Girl Scouts welcome, police don't enter. Does that change the analysis?
I personally wouldn't say so, because that would sound like a joke to me. And not a very reasonable answer, but could you possibly rephrase the question?
Well, I'm just trying to understand how much emphasis we put on the sign. In other words, you know, if we rule that way, then every house in America puts up a sign that says, you know, police can't come in, everyone else can come in. And does that then back the police up to only the public right of way?
To an extent, yes, but at the same time, there was no sign. So bringing it back to the facts, there was no sign, and there was nothing that obstructed the path from the police going up to his porch.
If they looked in his windows, that's now inside the home, but is that publicly accessible since the curtain wasn't pulled closed?
Not necessarily, because they were not able to see anything. Like they didn't look in the windows.
But in the case of if somebody did, if the police look in the windows and they see something, would that also count, or would that be protected under privacy? It is in the home, but visible to the street, or visible to the outside of the house.
I feel like that one could be argued both ways, because some people would say it is like a violation of privacy, but at the same time, if their curtains were open and you were visibly able to see that with just by walking by or something, then that's their choice by having their curtains open.
Was the tip drug related?
Yes.
You stated in your presentation that the tip was unverified. What do you mean by that?
That it wasn't confirmed.
Thank you, petitioners. We'll now have arguments from the respondents.
May it please the court. I am Luis King, and I'm here with my co-counsel, Eli Dickman and Mason Hall. Mr. Chief Justice and Associate Justice, we are here today to present the case of Florida v. Jardines. We are here representing the respondent, Jardines. The question of the case is whether or not a dog sniff at the front porch of a suspected grow house by a trained narcotics detection dog is a fourth right requiring a probable cause. We, as a respondent, we assert that the use of a dog is a tool is a violation of the Fourth Amendment right.
Police got a tip that Julie Jardines was growing marijuana. Two officers then brought a trained drug dog onto his front porch where the dog alerted to drugs. Using that alert, they then searched, they got a warrant and then they searched the house and found marijuana. We, the respondent, assert that bringing a drug dog onto the front porch, part of the house, making it an illegal search, Miami-Dade police should have required a warrant prior to entering the front porch of Jardines' home. We would like to direct the court's attention to Kelo versus United States, where officers used a thermal imaging device to gather information from the inside of the home without a warrant. The Supreme Court ruled this an unconstitutional search. Similarly, in Florida versus Jardines, officers used a drug dog to obtain information from Jardines' home without a warrant. We ask the court to uphold the same standards as Kelo versus United States and rule in favor of Jardines, holding that the use of such a tool constituted an unconstitutional search.
I would now like to direct the court's attention to the case of United States versus Jones. The case correlates to, both the cases correlate with the idea of trespassing. In United States versus Jones, police placed a GPS tracking device on the suspect's car without a valid warrant. The Supreme Court ruled that this was an unlawful search because officers physically trespassed on the vehicle to obtain other info. In Florida versus Jardines, officers brought a drug-sniffing dog onto the porch of the homeowner's protected porch of the homeowner, and that is a protected area, which makes it illegal. Both cases show the police cannot use tools, technology, or drug dogs to get around the Fourth Amendment.
I would like to divert the court's attention to another case, United States versus Dong. During this case, officers tracked certain chemicals used in drug making to Dong's farm. They entered the property, crossing multiple fences, and were able to observe a barn, but not entering. Inside the barn, they seemed to observe a drug manufacturing operation. They left at first, but then returned several times before obtaining a warrant. Dunn was then convicted on federal drug charges. The Supreme Court ruled that this was lawful search due to the fact that the barn was open and visible. In this case, which deals with the Fourth Amendment, strains the argument for Jardines, because in our case, they use a tool, a dog, which is a tool, and if they would have seen the drugs through an open door or window, the search and evidence would have been legal.
We urge the court to rule in favor of the respondent, Jardines. Our three precedent cases show his rights were violated. In Kelo versus United States, the use of a thermal imaging camera without a warrant constituted an unconstitutional search. In U.S. versus Jones, the use of a GPS tracking device to gather information without a warrant constituted an illegal search. And in U.S. versus Dunn, the court held that invading protected area without a illegal warrant. We ask the court to uphold these principles and protect the constitutional rights of Jardines and all Americans. Thank you, and we welcome any questions the court may have.
Questions from the panel?
You mentioned just right now that the porch is a protected area. Can you defend that idea?
So that would go along with the value of private property. Once you step foot on that property, that is their protected area, and being on there, you're under their liability. So you talked about earlier about how, Girl Scouts and stuff can come on your yard. Well, you can also trespass a Girl Scout if you really want to do, but you're not going to. So they're allowed to let you on there in certain reason, but it's still their area, you know, to have.
In your example, you used infrared, and you said that to detect the heat signature off of a grow lamp inside the house. But that is detecting something inside the walls of the house. This was detecting a smell that was outside the house. How are those two things parallel?
Yes, the smell was coming from inside the house, and they used the dog outside the house to gather information about the inside of the house, where the odor was coming from.
But the odor was physically present outside the house in that public space, whereas the infrared would not have been detectable without the use of a tool, whereas they said the officer also was able to detect it from the outside just by walking up to the front porch.
Yes, and they were on his private property to gather information from inside the house.
So is it the case that the officer was in fact able to smell it separate from the dog, or were they only able to detect the presence of marijuana through the use of the dog?
To my knowledge, they both detected it.
Yeah, like Mason said, they both detected it, but I believe it was not until they're up onto the porch that they both could detect it.
Is your statement that the presence of the dog as a drug detecting tool that negates or overrides the physical sensibilities of the officer to smell? Like, just because there was a dog present, that negates that the entire claim. Is that what you're saying? Because you have a human sniffer and a dog sniffer. The human sniffer picked up on it. The dog sniffer picked up on it. Are you saying that the presence of the dog sniffer negates what the human sniffer picked up on?
I feel yes, because the dog's nose is way more sensitive compared to the human nose. And the human nose can be deceived.
I think, if I can elaborate on what my co-justice just said, if the police officer had received the tip, he had walked up just to knock on the door to ask you questions, and had detected the presence by himself without a dog, if he just walked up to the door, and then said, "Oh, I clearly smell marijuana here," and then they started searching the property or whatever, that would have been okay? So if he had not brought the dog, that would have made it okay?
It would not have made it okay at all because he didn't have a warrant to search the house. So if he walked up and smelled it, he could go back and get a warrant and then come back and search it. But bringing the dog up there without a warrant, that doesn't make it okay.
I think.
Get a warrant after the dog smelled it, though?
Yes, they did.
Okay, so again, the same thing applies. They still got a warrant. There was the probable cause, but just because there was also a dog present, that seems to be the negating factor. Because if he just walked up there by himself, smelled it, got the warrant just like he did, it all would have been in order. So I don't see how a second corroborating tool negates his sense of the marijuana and then getting the warrant like you should.
I see it as the dog was used as a tool to gather more information, and the dog is trained to detect drugs. It is trained to search for drugs. That is why we believe it is illegal that the dog was there. That made it a search.
Thank you, counsel. Rebuttal from the petitioner.
So the dog is not a tool because it is a living and breathing mammal. Although it does have enhanced senses, it's not necessarily considered a tool because you can't just build it. And the dog was also sensing odors that were knowingly emitted to the air. Because let's say Jardine walked out of his home opened and closed his door. He knows that the smell is on him, and more than likely escaped from his home. And also, taking back to the property, there was no sign ever exhibited that it was private property. And yes, everybody owns their own property, but there was no sign that would make it so they were not allowed to go onto his property without having to physically be told by him. And since all they did was walk up to the home in a public manner, they walked up there, and the detective and the dog could both sense the presence of narcotics. That is then when they went and got a search warrant.
Questions? Seeing no questions, we'll have rebuttal by the respondent.
So they talked about how the dog is not a tool, which we believe is very false. Dogs are trained in the police force to detect and smell drugs. They're used all the time in searches of vehicles, especially on public roadways, which in this case, it was not a public place, so they weren't allowed to have the dog. So that's why, like, you're at a traffic stop or something, and they bring the dog out, they're allowed to do that because you're on a public roadway. But in this case, they were on his private property, which he owns, and it doesn't matter if there's a signpost or not, he still owns it, and he can make it his own private property if you want to do. And then she talked about how California versus Sorello, that's where they had they could see it with a tool, but also it was in public airspace. So they're allowed to do that and use that as a tool, that camera, to see behind that guy's yard, to see all the weed plants.
So if the dog is on the sidewalk, then outside in the public right of way and could smell the marijuana, then that'd be permissible.
Yes, I would be, but when they were up at the door, that's when it smelled it and singled for it.
I would like to add that they said the porch was public property. Just because it is accessible to the public does not make it public property. It is private.
If there are no further questions from the panel, we'll consider the matter of Florida versus Jardine submitted. Thank you, counsel. All right, the court is prepared to hear arguments in the matter of Jones versus Mississippi. Petitioners, you may proceed.
May it please the court. I am Brooklyn Daly, and I am joined by my co-counsel, Joanne Vargas Alvarez and Cale Weber. Today we are here before you representing the petitioner Brett Jones in Jones versus Mississippi. I rise to present my argument on behalf of the petitioner Brett Jones. The petitioner Brett Jones was 15 when he killed his grandfather, and he was sentenced to life without parole. He was given a mandatory life imprisonment charge by the Circuit Court of Lee County, Mississippi, and Mississippi law made him ineligible for parole. The question in this case is, does the Eighth Amendment require a sentencing authority to find that a juvenile is permanently incorrigible before it may impose a sentence of life without the possibility of parole? We, the petitioner, say no. We argue that a sentencing authority must find a juvenile permanently incorrigible before giving them a life without imprisonment charge. We are not here arguing for the petitioner Brett Jones' freedom, but we are here arguing for him to have the possibility of parole. In the case of Jones versus Mississippi, the petitioner Brett Jones argues that the Eighth Amendment demands a finding of permanent incorrigibility before giving a juvenile life without parole. This is supported by precedent cases such as Miller versus Alabama, Montgomery versus Louisiana, and Roper versus Simmons.
The first case that we would like to cite as persuasive authority is Miller versus Alabama. And originally they found fault in the ruling for the Eighth Amendment in this case. In this case, Evan Miller along with Colby Smith beat and killed Cole Cannon. They then set fire to the trailer that he was in. They were only 14 years old at the time. The primary holding for this case was that no juvenile defendant may have a mandatory life sentence of imprisonment without the possibility of parole, no matter how serious the crime. The court determined that there's a constitutional distinction between juveniles and adult for sentencing purposes. They failed to account for the immaturity and the capability of change of juvenile defendants. In accordance with the precedent and established law, the petitioner Brett Jones should be sent to prison with the possibility of parole.
Next, we would like to cite the case of Montgomery v. Louisiana. The Supreme Court held that its earlier decision made in Miller v. Alabama applied retroactively. They emphasized that Miller set a substantive constitutional rule in the Eighth Amendment's protection against cruel and unusual punishment. The court reaffirmed that children are different from adults, stating that the youth have a capacity for change and a high potential for rehabilitation. The court stated that life without parole was reserved only for the rare juvenile offender whose crime reflected permanent incorrigibility. In accordance with Montgomery v. Louisiana, petitioner Brett Jones is entitled to a sentence considering his youth and capacity for change. The final case cited is that of Roper v. Simmons. In this case, the Supreme Court decided that the execution of minors was a violation of the Eighth Amendment's protection against cruel and unusual punishment. The court stated that they could not extinguish one's life and potential to attain a mature understanding of their own humanity. This acknowledges that juveniles are still developing and that the opportunity for rehabilitation should not be taken away from them. This ruling establishes the difference between juveniles and adults in sentencing, and in accordance with the precedent, petitioner Brett Jones should receive a sentence considering the developmental differences between juveniles and adults.
We implore the court to uphold the principles of justice and fairness. We respectfully urge the court to recognize that the Eighth Amendment demands a finding of permanent incorrigibility before a juvenile can be sentenced to life without parole. Juveniles cannot receive mandatory life without parole charges because Miller v. Alabama says that this is unconstitutional. Montgomery v. Louisiana reinforces Miller v. Alabama, and Roper v. Simmons says that juveniles and adults are constitutionally different. Upholding this principle preserves the integrity of our Constitution and the values of justice it represents. My co-counsels and I urge to recognize that based on our precedent cases, sentencing juveniles to life without parole is a direct violation of the Eighth Amendment. Thank you, Your Honors, for your attention and consideration. I yield the floor to my opposing counsels for their perspective.
Thank you, counsel. Questions from the panel?
All the cases that were cited have reactive murder, so a planned murder would be very different than obviously a reactive murder over an argument or different cases when it's these cases that had somebody that's reacting to an argument or disagreement that they had in these cases.
What were the circumstances of the killing in this case?
So it started with the petitioner Brett Jones and his girlfriend. They were in his bedroom. And at the time, he was living with his grandpa because he moved from Florida to Mississippi. He got into an argument, and his grandpa wanted his girlfriend to be out of the house. So when she decided to leave, he was making a sandwich in the kitchen, and him and his grandpa got into an argument, not over his girlfriend having to leave, but I think they were both upset about that, and that kind of like heightened their senses, especially Jones. And Jones sassed his grandpa, and this got them into a fight. It didn't start right away with a stabbing. They were both swinging at each other, and then it later led to Jones stabbing his grandpa.
So your argument is that the trial court would have to find the juveniles permanently incorrigible. What factors would go into that? I mean, couldn't the court determine that essentially if you kill someone that's per se or by definition incorrigible?
To be incorrigible, you have to be beyond correction or unable to change. And in the testimony, Brett Jones' mother talked about how he was a good kid. He was on antipsychotic medication, but at the time he wasn't, and he also endured abuse when he was younger from his stepfather. So we argued for that he wasn't because he was found not incorrigible.
Thank you, petitioners. Respondents?
Mr. Chief Justice, and may it please the court. My name is Reagan Van Zanten, and I'm here along with my co-counsel, Maya Klawandrink. Today we represent the state of Mississippi. This case is about discretion and trusting a judge to consider a young person's age and circumstances before deciding a fair sentence. The question we are addressing is not whether a juvenile can ever get life without parole, it's whether a judge must prove that the juvenile is permanently incorrigible in order to impose that sentence. We ask the court to affirm the lower court's ruling that the judge did not need to find Mr. Jones permanently incorrigible in order to impose life without parole. To understand why this sentence was constitutional, let's look at the key question before this case. The constitutional question we ask you to consider is whether the Eighth Amendment requires a sentencing authority, such as a judge or in special cases a jury, to find a juvenile permanently incorrigible, meaning incapable of meaningful rehabilitation or change, also known as the seriousness of the crime outweighed the ability to change before imposing life without parole. Our answer is no. A judge does not need to prove that a juvenile is permanently incorrigible in order to impose life without parole.
A closer look at the Eighth Amendment reminds us that excessive bail shall not be required, excessive fines should not be imposed, and cruel and unusual punishment should not be inflicted. The Eighth Amendment protects citizens from cruel and unusual punishment, but it does not require a specific finding of permanent incorrigibility.
In addition, the Eighth Amendment doesn't require a judge to make a factual finding that the juvenile is permanently incorrigible in order to impose life without parole. This is because juvenile life sentences are already heavily reviewed. Judges must consider youth, not prove incorrigibility, and sentencing discretion was provided.
To understand how Mississippi's sentence was constitutional, we first have to look at the background of our case. At 15, Brett Jones stabbed and killed his grandfather during an argument at their home in Mississippi and was convicted of murder. Jones had 2 sentence hearings, and both times he was given life without parole. Although Jones argued this violated his Eighth Amendment rights, it did not, because the judge exercised lawful sentencing discretion and a finding of permanent incorrigibility was not required. To understand how the court views juvenile life sentences, we can first look at Graham v. Florida. At 16, Terrence Graham was convicted of armed burglary, and after serving a 12-month sentence, he was convicted of armed robbery and was given a life without parole sentence. The court ruled that this violated his Eighth Amendment rights, stating that juveniles cannot get life without parole for non-homicide offenses. Graham confirmed that only homicide cases can get life without parole. Our case gives the court an opportunity to clarify how this should apply in homicide cases.
Although juvenile life sentences are already heavily reviewed, we must look at how a judge must consider youth, not proven corrigibility, as seen in Miller v. Alabama. In 2003, 14-year-old Evan Miller was charged with mandatory life without parole for killing Cole Cannon. He filed a post-trial motion that this was against his Eighth Amendment rights of cruel and unusual punishment. The court ruled that automatic life without parole for juveniles violated the Eighth Amendment, but the justices did not ban life without parole entirely. Judges could still impose it if they considered their age and circumstances. Miller left the ultimate decision to the sentencing judgment. Just like Alabama, Mississippi let the judge think about the teen's age and situation, then decided the sentence. Because of that, Mississippi followed all of the rules and therefore did not violate the Eighth Amendment. Even though age and circumstances must be considered for life without parole, sentencing discretion was provided as seen in Montgomery v. Louisiana. In 1963, Henry Montgomery was 17 years old when he was charged with life without parole for killing Charles Hunt. He originally appealed to Louisiana Supreme Court and his conviction was overturned. Once he was retried, he was again convicted of life without parole. The court ruled that Miller v. Alabama applied retroactively, meaning that cases before Miller could be reviewed. Montgomery clarified that life without parole should be rare and reserved for permanently incorrigible juveniles, but judges weren't required to prove this. Like Montgomery opened the door to rechecking old sentences, Jones is about figuring out what the rules are once that door is open. The judges still had the power to decide the right sentence as long as they considered their age and circumstances.
With life without parole being permitted for homicide cases, Brett Jones' sentence was constitutional and the judges properly considered his age and background. The question we are asking is not whether a juvenile can ever get life without parole, it's whether the Constitution requires the judge to first find the juvenile permanently incorrigible. Therefore, we ask the court to affirm the lower court's ruling in favor of Mississippi, as the Eighth Amendment does not require a judge to find permanent incorrigibility before imposing life without parole.
Thank you, counsel. Wouldn't a finding of permanent incorrigibility, though, be consistent with those cases in that I think it was the Miller case you talked about considering the circumstances, and wouldn't it further support the purposes of the juvenile justice system of, you know, if a child can be rehabilitated or can change, grow, and develop, then they wouldn't be sentenced for life. Isn't it consistent with all those things?
Could you rephrase that, please?
Sure. So in Miller versus Alabama, I think that the court talked about considering the circumstances of the child. And one of those circumstances from all of the cases seems to be whether the child can change. So doesn't us using the words permanent incorrigibility and requiring that help clarify how a court should determine whether a child can change?
Yeah, but in Montgomery v. Louisiana, it stated that cases before Miller would apply retroactively, and they should be reviewed. And permanent incorrigibility shouldn't be a part of the discretion. I think that the crime is bad enough that you shouldn't have to consider if they should change or not. It outweighs the possibility of them changing.
If there are no further questions, we'll move on to the rebuttal by the petitioners.
First, I'd like to say that Brett Jones wasn't found incorrigible by the lower courts. The lower courts didn't care if he was found incorrigible because of the ruling of the lower courts. This is because all the lower court rulings had life without parole sentencing for all murder cases, and the state rulings are different from the Supreme Court rulings, and based on the previous precedents, it should be changed.
We were also wondering how you can prove that a judge considered the youth. And they also talk about discretion a lot. We wonder how a judge can use discretion while also not having to use the incorrigibility against, because he used this as self-defense when he got into the fight with his grandfather. And he called 911 and he gave him CPR. And he did everything to make sure, like, because he used it as a self-defense. He didn't try to kill him on purpose. So we kind of wondered how they're going to use discretion but not put incorrigibility into play with it.
Questions?
Why wouldn't it be better to trust individual courts and decisions rather than making a blanket rule for the whole United States? For example, I mean, in this case, shouldn't we trust the appeals process, not just the original case, but also the appeals process, because it would have to be decided multiple times against the defendant in this case, and if that many people felt like life without parole was the appropriate punishment, why wouldn't you trust them rather than making a blanket rule?
If you're saying like that would be the blanket rule, that would be the blanket rule for those individual states. Once this is brought to the Supreme Court level, it falls into the Supreme Court ruling, and that's different than the ruling that those individual states have.
Right, but I'm saying, why do that? Why remove one of the options rather than letting local courts decide what they feel is best? Like leave the decision more local and individual to that particular case, and then trust the appeals process and trust the original case rather than artificially restrict it at a national level.
Mississippi law made him ineligible for parole no matter how old he was. Like, that was just the law when the case happened.
So basically, those judges in the lower courts wouldn't have even been able to make the discretion because they had already proven him guilty for that crime, so they had to give him that punishment. There was no discretion in the lower courts that could be in the higher courts.
Thank you, counsel. Rebuttal by the respondents.
The court issue is simple. Does the Eighth Amendment require sentencing authorities to find a juvenile permanently incorrigible in order to impose a life without parole sentence? Our answer is no. Miller requires only the judge to have discretion and consider youth, which Mississippi provided through a full individualized hearing. Neither Miller or Montgomery demands special words or a factual finding. The judge recognized Brett Jones' age and background and still found life without parole appropriate given severity of the homicide. Mississippi's sentence was constitutional and provided discretion, not guaranteed a lesser sentence.
Questions?
They're arguing on the other side that the judge didn't have discretion, that he had to give him life without parole. Why not give him that discretion to be able to choose to sentence him without making a permanent?
Can you rephrase that, please?
Sure. It seems like there's a discretion issue, like restricting, can you give them different sentences or not? And you're arguing for, hey, they should be able to give this kid life without parole. So you're arguing for more discretion, but yet if what they're saying is true, that the lower courts couldn't have even done it a different way, shouldn't it again be better to just trust individual judges for individual cases and allow them to decide on a case-by-case basis whether he had parole or not?
Yeah, so they were considering his age and background, but they're arguing that they shouldn't have that he couldn't find permanent incorrigibility, but isn't that essentially what the case is about? Like, they're arguing that you need to find him permanently incorrigible before he goes to a life without parole sentence. But we're arguing that you don't need to consider that, outweighing how bad the crime was.
We will now consider the matter of Jones versus Mississippi submitted. Thank you, counsel. All right, the court is now prepared to hear arguments in the matter of Potawatomi versus Earls. Petitioners, you may proceed.
Mr. Chief Justice, and may it please the court, my name is Miguel Andres, and this is my associate Gaspar Andres. We represent the petitioner Potawatomi School District. We ask the court to reverse the lower court's decision based in favor of Potawatomi.
The constitutional question. Can a school require all of its students to take a drug test as a condition for participating in voluntary activities without violating the Fourth Amendment's protection against unreasonable searches and seizures?
The Potawatomi School noticed a growing concern about drug use among their students. The district created a policy requiring all students who choose to participate in extracurricular activities such as choir, academic teams, and sports to take a drug test. Two students, Lindsay Earls and Daniel James, and their parents said that this was a violation of the Fourth Amendment and it was unfair to make students take drug tests. The school said this was not a violation of the Fourth Amendment because extracurricular activities are voluntary and the school has a right to keep students safe from drugs.
The school's district policy allows it to require drug testing for all students who wish to participate in voluntary activities without violating the Fourth Amendment. This is constitutional because, one, the school activities are voluntary, two, the school has a compelling interest to prevent drug use, and three, the school has the authority to conduct searches in the school.
The most relevant precedent case to our case is Vernonia v. Acton. And Vernonia v. Acton is another case about schools requiring students to take drug tests. The Vernonia created a policy requiring students in sports to take a drug test. Acton refused to take the drug test and was barred from participating in sports. The policy for Vernonia and the policy for Potawatomi are not a violation of the Fourth Amendment because extracurricular activities are optional, are voluntary. We asked the court to reverse the lower court's decision based on Vernonia v. Acton.
Not only is this constitutional based on activities being voluntary, but this is also justifiable because it promotes safety. In Skinner v. Railway and Labor Executives Association, the federal government required its employees who were involved in accidents or who are in safety-sensitive jobs to take a drug test. The workers refused and argued that this violated the Fourth Amendment. The Supreme Court ruled that this did not violate the Fourth Amendment because the federal government had a compelling interest to keep the public from harm and stated that the the drug testing in dangerous environments were reasonable measures. Just like in Skinner, in this case, the school district's policy for drug testing and extracurricular activities protects students and maintains a safe environment. In both of these cases, the drug testing prevents harm for students and workers before any serious problems could occur. Schools protect students and sets a safety assurance, just like how the government did for their workers. This shows that drug testing to ensure safety is constitutional, and the lower court should rule in favor of Potawatomi.
Additionally, in New Jersey v. TLO, TLO was caught smoking by a teacher, which led to the principal searching her purse and finding evidence of drug use. TLO said that the school did not have a warrant or probable cause to search her purse, and it violated her Fourth Amendment. The court stated this was not a violation of the Fourth Amendment because schools do not need a probable cause or a search warrant and only need a reasonable suspicion to search her purse in order to act fast and maintain safety. The court also stated that schools must balance the student rights and the school requirement to keep students safe.
In conclusion, Potawatomi's policy does not violate the Fourth Amendment based on Vernonia v. Acton, where students have to accept certain conditions for the school to keep everyone safe. In Skinner v. Railway, the government is required to drug test to prevent harm and provide safety. In New Jersey v. TLO, a student's privacy is reduced at school, allowing schools to take reasonable measures to keep everyone safe. Safety and rights must be balanced. If schools can't even prevent students from taking drugs, how can they be trusted to take care of the kids? Thank you.
Thank you, Council. Questions?
I'm assuming this is drug testing in the Snoop Dogg sense, not in the Lance Armstrong sense. So not performance-enhancing drugs since it is sports. I just wanted to clarify that.
This policy covers more than just sports, doesn't it?
Yes.
So what's the school's basis for testing more broadly outside of sports in terms of the safety concerns?
Can you rephrase that?
Why does the school want to test other extracurricular activities besides just sports? What's their safety concern or their other concern?
Because the students represent the school, and sometimes the activities involve going outside of school, and it's in order to keep them safe as well.
So if student safety beats student rights, we'd all agree that drugs are bad for your brain. Could I drug test any student that I feel that might be on drugs?
No, you can't. All students have to take the test, not just like a certain individual. Everyone must.
Well, the activities are voluntary, so if they don't want to take the drug test, then they don't have to join the activity. And we're also not enforcing the drug test on them if they're not in the activity.
So student athlete safety beats student rights?
Yes.
You lose some of the rights once you join the activity.
If there are no more questions, we'll move on to the argument from the respondents. Thank you, petitioners.
Chief Justice, Associate Justices. To please the court, I'm Trista Vant Hall, here with my co-counsel, Caleb Baker, Gabe Gruneweg, and Haley Boone. We are here to discuss the case of Potawatomi versus Earls, and we are on the Earls side.
The question that our case is asking is the student activities drug testing policy, which requires all students in competitive extracurricular activities to submit to drug testing consistent with the Fourth Amendment. As the respondents of this, the answer is no. Lindsay Earls argued that drug testing students violated the Fourth Amendment because it imposed searches on students without having a cause. She also argued that the school showed no evidence of a drug problem among the non-athletic extracurricular participants, and that these students had a higher expectation of privacy than the normal athletes, and that this conditioning participation core school activities on submitting to such searches was unreasonable. In Tecumseh, Oklahoma, the Potawatomi School District required all middle school and high school students in extracurricular activities to submit to drug testing. They cited two students from the school, Lindsay Earls and Daniel James, argued this policy, saying that it violated their Fourth Amendment because there was no evidence of a drug problem. This case raised a constitutional question of how far schools can go with drug testing their students.
Starting off with this case, Verona School District versus Acton, it's when students were getting random drug testing, urinal drug testing, the school adapted the student-athlete drug policy. Respondent Acton was denied participation in his school's football program when he and his parents, also respondents, refused to consent to the testing. They then filed this suit seeking a declaration and injunctive relief because the policy violated the 4th and 14th Amendment and the Oregon Constitution. The district court denied the claims, but the Court of Appeals reversed, holding that the policy violated both the federal and state constitutions. The difference between this case and ours is that they had a reasonable reason for the search and seizure. Our cases of Potawatomi versus Earls had no reason for the drug testing, making it unreasonable search and seizure, violating the rights.
The next case we would like to provide as precedent is Chandler v. Miller. This case is about the unconstitutional drug testing, which held that Georgia's mandatory drug testing law for candidates for public office violated the Fourth Amendment, much like it did in Potawatomi versus Earls. The court ruled that the statute infringed upon the right to be secure against unreasonable searches and seizures, as there was no sufficient special need to justify a suspicionless search of all candidates.
The final precedent case in which we have is New Jersey v. TLO. This case is over school officials searching TLO after being caught smoking in the bathroom with another fellow student. Officials searched her bag looking for the cigarettes, and once found the cigarettes, they continued searching. They found rolling paper, marijuana pipe, and a list of names of students who owed her money. TLO felt offended and brought this to higher authorities, subsequently to the courts, stating how schools cannot search without reason of suspicion. And then this weekends protection for all students from suspicionless searches. The core of our argument is that the Fourth Amendment right protects students from unreasonable searches and seizures. The school board had no proof of students in non-athletic clubs, such as the academic team, have drug problems, yet they're forced to take drug tests to participate. These students have rights to keep their private lives private, and forcing them to choose between their school dreams and their constitutional rights is unfair and unreasonable. If allowed, we destroy the broader principle of privacy for all students and undermine the balance between school, authority, and individual rights. In conclusion, Earls reaffirms that fundamental constitutional liberties must be preserved unless the government can demonstrate a specific, credible, and legally sufficient basis for suspicion.
Didn't the school have some finding before it adopted this policy that there was a drug problem at the school?
Yes.
So then isn't it reasonable if students are going to be representatives of the school and these extracurricular things to require that they be drug-free?
Could you reset that question?
Sure. So if we know there's a drug problem at the school, then isn't it reasonable to say, look, if you're going to participate in an extracurricular where you're going to leave the school and be in some form or another a representative of the school, isn't it reasonable to have the school desire that those people be drug-free, not on drugs?
I would say that they wouldn't be on drugs. Like, they would be drug-free in those extracurricular activities.
But how does the school know that? I mean, if there's a drug problem, how do they know that the students that are participating in the extracurricular activities are drug-free?
Just because one student tested positive for drugs does not mean that all the other students are part of the drug usage in the school.
Thank you, respondents. Rebuttal from the petitioners.
The respondent said that there was no drug problem, which would make the policy unreasonable. But the school has a job to protect students and make sure that they're safe and while they're away from home. Schools don't want something bad to happen before they create like a policy. They want to make sure nothing happens and prevent any harm from parents' kids.
And also, we like to say in Skinner v. Railway, it shows that drug testing to ensure safety is constitutional.
What's the connection between, if you're you're doing speech and you use marijuana, what's the safety issue here? I mean, what's the concern on the school's part?
Well, if you're on drugs, you might not be thinking straight, and you might say something bad, and this could affect the school's because you're representing the school, and you can make the school look bad if you say something bad because you're not thinking straight.
But isn't that then protecting the school and not the students?
Well, this will also be protecting students because their reputations would be harmed.
Thank you, petitioners. A rebuttal from the respondents.
Students couldn't say no to the test without being rejected from such activities, like the extracurricular activities that they want to join.
And then being taken out of class to take these drug tests can be embarrassing for these students, and these could be unannounced drug tests for these students as well.
Counsel, though, if they were announced drug tests, I mean, it seems like it'd be pretty easy to game the system then. Doesn't the school have some compelling interest to protect its reputation and the students' reputations, as petitioners suggest?
Can you say that again, please?
Sure. Doesn't the school have some reason to protect its reputation and the students' reputations, and doesn't the drug testing accomplish that?
No, because I feel that maybe drug usage isn't the only problem that could be in the school. There could be worse problems.
Such as?
Fighting, bullying, anything really. There could be worse problems than drugs. And so if a kid did smoke marijuana once and they're trying to get into an extracurricular activity, but they can't just because of one mistake that they made, if that makes sense.
Do you feel like the school should be able to set rules for their extracurricular activities?
I'd say so, yes.
But not this one?
But not to this extent.
Thank you, counsel. We will consider the matter of Potawatomi versus Earls submitted. All right, the court is prepared to hear arguments in the matter of Georgia versus Randolph. Petitioners, you may proceed when you're ready.
Mr. Chief Justice, may it please the court. We represent the petitioner in the state of Georgia case, Georgia v. Randolph. Imagine a circumstance where the police respond to a domestic dispute and one resident who shares the home allows the police officers to search the home, but the other objects. Does the voluntary consent of the person that lives there that allows the police officers to search the home, does it make that invalid?
To provide some context on this case, Mr. and Mrs. Randolph were involved in a domestic dispute concerning narcotics in their home. Upon arrival, law enforcement was informed by Mrs. Randolph that Mr. Randolph possessed cocaine in the house. Police officers went up to Mr. Randolph and requested permission to search the home, in which he expressively denied. They then went up to Mrs. Randolph and requested permission to search the home, in which she gave them voluntarily, meaning she was not forced into saying yes. She even led them into the house herself. In the home, law enforcement found a straw containing traces of cocaine on it, leading to Mr. and Mrs. Randolph's arrest.
The key question of this case being, can police search a home when one physically present resident consents and the other physically present resident objects? The issue with that being the objector was physically present. If they were not physically present, we would not be here. This case would have clear, concise consent by the homeowner.
The first precedent case we would like to cite is the case United States v. Matlock, where police got permission from the woman who shared the home to search the home. Matlock was suspected of bank robbery, and when police arrived at the home, he was arrested in the front yard. Law enforcement then went up to the front door and asked the woman there if they could come in and search the home, in which she gave them permission to voluntarily, meaning that she was not forced into saying yes. When police got into the home, they found $4,995 linked to Matlock. The Supreme Court ruled that this search was reasonable under the Fourth Amendment because the woman had shared authority and gave voluntary consent. Shared authority means that two co-occupants live in the same home and have control over the home, meaning that both of them have the power or the right to allow somebody into the home, even if it's law enforcement. In Georgia v. Randolph, the state of Georgia relied on this ruling to argue that Mrs. Randolph's consent was reasonable under the Fourth Amendment because she also gave voluntary consent and had shared authority over the property. Georgia v. Randolph and United States v. Matlock are similar cases because both the women in these cases had the right to allow law enforcement in. The case United States v. Matlock is an important precedent case because it ruled that one co-occupant's consent is enough under the Fourth Amendment if the occupant has shared authority, meaning that Mrs. Randolph's consent was valid under the Fourth Amendment, even though Mr. Randolph expressly denied.
The second case we would like to cite in our argument is Illinois v. Rodriguez, a case where a woman claiming to have been beat by Edward Rodriguez allowed law enforcement to search their apartment. She continuously referred to the apartment as our apartment, leading to law enforcement to believe that she was still a resident even though she had moved out prior to this. Supreme Court ruled that this was allowed due to apparent authority. Apparent authority is when entry is allowed under the assumption that a person has the power to consent. In that case, constables will not be at fault for entering the premises. Applying this logic to Georgia v. Randolph, Janet Randolph had apparent authority and legally consented to law enforcement being in the house.
For our final argument, I'd like to present you the precedent case Schneckloth v. Bustamante. This was a pivotal case defining voluntary consent under the Fourth Amendment. The court held that the person's consent is valid if freely and voluntary, even without knowing their rights. In Georgia v. Randolph, Mrs. Randolph's consent was clearly voluntary, no coercion or deceit. She willingly allowed officers to search. Consequently, the search should be deemed lawful under the same principles that guided Schneckloth. Therefore, Schneckloth supports Georgia's claim that voluntary consent from one occupant is constitutionally sufficient regardless of another's objection.
As petitioner, we ask you to rule in favor that a consent of one homeowner is enough, despite objection, because of shared authority by U.S. v. Matlock, apparent authority, Illinois v. Rodriguez, and voluntary consent supported by Schneckloth Bustamante. We implore the court to uphold the principles of justice and fairness. This case should have allowed law enforcement to legally search the home without any backlash. We ask you to please rule in favor of the petitioner, and we thank you for your time and consideration.
Thank you, Counsel. Questions from the panel?
Did you say that they spoke to the husband or the gentleman first, and he said no, and then spoke to Janet?
Yes.
Do you see that as important or essential information that they first heard from an owner no, and then found somebody who said yes?
Well, they were both present while asking, so they just happened to ask him first.
What about a scenario where the husband says no and the wife says yes, and so the searching officers can only find something against the wife? Is to say, since the husband did not consent, when they do a search of the property, if they find anything incriminating against the husband, it wouldn't count or wouldn't be admissible in court because he didn't give consent, but she did.
So you're saying just because she gave consent, any illegal substance, it incriminates the husband?
No. Right. Well, no, if she gives consent, then they can search her stuff, but not his stuff. Because he didn't give consent.
It's tricky
so
if...
he still maintains his privacy, even within the confines of the home, so they have to ignore or exclude what they might find that belong to him.
Which, yeah, it's tricky if they're, in this case, they're married, so they're in the same room, and they're in the same bedroom. So I guess the only thing you could exclude is maybe his dresser, but really everything else is up for search.
But I'm saying anything that he says, I mean, anything that belonged to him, he could say, I didn't give you permission to search my things, and this is my things. If the cocaine or whatever was belonged to him and not to her, he said, this belonged to me, and I didn't give you rights to search my part of the building.
I think you could argue that since I guess they're both under the ownership of the house. Everything in the house can be up for search under the warrant.
Was it clear in this case that both of them were owners?
Yes.
Would it matter if that was the case, and if so, how are police to determine while they're on a scene who the owner is and what the implications of that are?
So apparent authority is when law enforcement believe that the owner's consent is enough to enter. So when we were speaking of the Illinois v. Rodriguez case, the woman was not actually a resident anymore. She had moved out 3 weeks prior. But because she continuously said that she was still living there and it was her residence, law enforcement didn't have any information otherwise. So apparent authority allows them to go and search that home, even if they didn't live there.
If I stand out in front of somebody's house and say, I own it, can I invite the police, can I tell the police to go search it? But because they mistakenly thought I was the owner in that moment, then it makes the search legal?
Well, she was being beaten by Edward Rodriguez, and they were in a relationship. So there was information that connected her to that residence, but she just wasn't living there at the time of the search.
Thank you, petitioners. We'll hear arguments from the respondent now.
Mr. Chief Justice, and may it please the court, I am Kaylee DeYoung here today with my associates Alexis Finvorst and Emma DeYoung, and we are representing the respondent, Mr. Scott Randolph. Our case asks one key question. Can police search a home when one physically present resident objects and the other does not? The Fourth Amendment states that we have the right to be secure in our homes. The state of Georgia asked the court to fundamentally weaken this law by ruling that police can ignore the refusal of consent. We maintain that when a co-occupant is physically present and verbally tells the police that they may not search, the police have one constitutional choice: to get a warrant. To rule in favor of Georgia turns the Fourth Amendment into a coin flip. It means your right to privacy can be vetoed, not by a judge, but by a simple disagreement at your front door. We urge this court to uphold and affirm the inviolability of the home and rule that the search of Scott Randolph's home was unconstitutional.
The search in this case was unconstitutional because the presence of a co-occupant who expressly denies the search overrules any consent by the other resident. The home may not be searched without a warrant, valid consent, or exigent circumstances, thus invalidating the search and violating the objecting individual's Fourth Amendment privacy rights. Scott Randolph was in his home when the police responded to a domestic dispute over the custody of their son. And the search only happened because his estranged wife reported his alleged cocaine use. Randolph clearly and firmly refused the search, asserting his privacy rights. But despite this refusal, the police still searched under his wife's consent and later used the evidence found against him. His refusal demonstrates that a physically present resident's refusal should control whether a search may occur and overriding his fundamental rights.
Mr. Randolph was present when he objected to the search. This is a key distinction between this case and United States v. Matlock. The core argument in the Matlock precedent is that one occupant is allowed to consent when the other is absent. This does not apply when the co-occupant is present and expressly objects. In Matlock, the absence implied that he knew the assumption of risk, that the consenting person would let the police in. Scott Randolph, however, was physically present and flatly refused consent, which instantly negates the assumption of risk from Matlock. The bright line rule must be that consent is invalid in the presence of the objecting occupant. Therefore, in our case, a warrant was required, because the police cannot override a resident's objection. They have no greater authority over a home than a private guest one resident lets in, but the other, standing at the door, explicitly says to stay out. Furthermore, without a warrant, consent, or exigent circumstances, the Georgia Supreme Court's ruling should be affirmed. In Payton v. New York, police entered the defendant's home without a warrant to execute an arrest for murder. The court held that this violated the Fourth Amendment right, emphasizing that a person's home is their most protected space. This established the general rule that the Fourth Amendment draws a firm line at the entrance to the home. Scott Randolph's objection proved that police had crossed this firm line without a warrant, consent, or exigent circumstances. There were no exigent circumstances present because there was no imminent danger of a person, escape of a suspect, and police could have prevented removal or destruction of a substance by placing a watch upon the home while they obtained a warrant. By proceeding over a present occupant's refusal without a warrant, consent, or exigent circumstances, the police violated this fundamental rule established in Payton.
To further interpret the Fourth Amendment protection as it extends beyond the property itself, in Katz v. United States, the court held that the Fourth Amendment protects people and not just the place. When Katz had reasonable expectation of privacy was violated when the FBI recorded his phone call in a public phone booth without a warrant. Katz took steps to secure his privacy, and the government's warrantless monitoring unlawfully intruded on this. Likewise, Scott Randolph was present and clearly refused consent to the search, and explicitly asserted his privacy that cannot be overridden by his wife's consent. Likewise, Katz's privacy could not be dismissed because he stood in a public phone booth. The Fourth Amendment therefore shields Randolph and his home from a warrantless search.
So can police search a home when one present occupant objects and the other consents? No. Your Honors, Mr. Randolph's home was constitutionally protected under the Fourth Amendment. Mr. Randolph's refusal should have overridden any consent given by his estranged wife. If one argument or no at your front door can override any consent or objection of consent, then no home in America is truly private. We ask the court to uphold the Constitution, respect Mr. Randolph's objection, and affirm that the search was unconstitutional. Thank you.
So wouldn't a ruling though in your favor create a little bit of a boondoggle for the police? Assume a slightly different scenario where he asks the police ask the spouse first, she says yes, he says no, she says yes again. Can they search?
So the factor of this case is that she was estranged and was no longer living in the house and had moved to Canada previously.
But if she's still on the deed, can't she give consent?
Technically, she can give consent, but as of right now, with the rulings, when this case occurred, there was no ruling that gave precedent where one person was there and consented and one was there and objected. So the fact that both of them were present and one gave a consent and one objected, your privacy should prevail in that situation.
And so let's assume an apartment then, here we've got one consent and one objection. Would the same be true if there are, say, 6 occupants of the apartment, 5 say yes and 1 says no?
In that situation, I feel it would be up to the discretion of the police, since there is a majority vote versus a minority vote, where in this case it would be 50-50 consent. The police in this case were called for a domestic abuse about custody for their child, not for drugs. So they were not responding to a drug call, they were responding to a domestic dispute.
But if this was that case precedent,
right,
then that would also be applicable further down the line in a situation like you described. Is that something that we want to say?
It's also to take into consideration with this case. They didn't know about the drugs till after they arrived. So it was a later consideration. If they called about the drugs beforehand, I would say the consent of 1 would be fine because there's also probable cause there that there were drugs.
Thank you, respondents. Rebuttal from the petitioners.
The opposing side mentioned that they crossed the firm line, but they had consent. And being married means that you're sharing your life with one another. And as they said, it was a domestic dispute on the consent. So the issue of who gave consent and who didn't give consent was a domestic dispute, and they should have argued together on whether the police were allowed in, not just separately. That's why it was a domestic dispute and not a Fourth Amendment violation.
I would also like to add, if this, say Mr. Randolph wasn't even there and Mrs. Randolph allowed the police to come into the home, they're not going to call Mr. Randolph to ask if they can have permission. They will search the whole home in her permission. So if he wasn't there, this case wouldn't be a question and we wouldn't be here today. Yes, because it's in their home. And
if you were in a shopping mall and you have a weapon in your backpack, nobody knows the weapon's there, you've not used it, you've not drawn it, I mean just tucked in there. Can the owner of the shopping mall give the police permission to search your property? Because you're in a business, you know what I mean? But it's your thing within somebody else's structure building. In the same way the drugs were one person's personal items within even if the other person owns the structure, can they also give access to everything in that structure? Does that supersede my things within a structure?
Well, a shopping mall is open to the public, and this home is private. That's why it's consent. And if you're carrying a weapon into a public space, that obviously takes precedence, and police are allowed to go into the public space and obviously keep everyone safe there.
And if someone was to hear about this weapon in this mall, that's also probable cause. With a warrant or not, they can go and take that person into custody wherever they are.
Thank you, petitioners. A rebuttal from the respondents.
I would like to remind the court once again that the domestic dispute in this call was not about the drugs, but it was about the custody of their son. And that she was estranged and moved to Canada beforehand, so technically they did not have shared authority as he was the primary resident. And Randolph denied first, then Janet was asked after the fact that he denied. And she was the one who was estranged and no longer lived there.
In United States v. Matlock, the precedent is that one resident can consent when the other is absent. Therefore, this case does not have as much of an applicable situation as when the residents are both present and one objects. If one resident was absent, we would not be hearing this case. Since both residents were present, this case does not have valid relativity.
Does the order of the consent matter? If they had happened in the opposite order, would that make a difference?
Think about it in the sense, like, if your child goes to one parent and says, hey, can I go to the park? And you say, no, you cannot go to the park. And they go ask their mom, hey, can I go to the park? And they say yes. Should your child go to the park? We don't believe the child should go to the park.
If there are no other questions from the court, then the matter of Georgia versus Randolph is submitted. Thank you, counsel.